Lordship may not misunderstand me, my lord. Normally, I would not listen. Item 2. I confess, one is a big brief. I have not read that brief. Lordship may call it after 2 weeks. Sure. Interim order to continue. There's an interim order. Grateful, man.
But big brief, in fact, the big volume brief
No.
scares the court, not the lawyer.
It came very late, actually, yesterday night. I did not have any more patience to go.
Keep it. Yes.
Grateful. Pardon to my mention by law. One modification, I have filed memo. Matter will be urgent.
Modification. Yes. Any out of list mentioning?
Item.
Out of list mention. No. Okay. List.
You mention item 1 to 6, 7 to 17.
Item 16 also item 16 I prefer an adjournment.
Why are you always you are asking adjournment? I have seen you. Have you read what is the fact? At least tell me. You have become a master in adjournment. Have you read it? What is the case?
Cognizance challenging the order of cognizance.
What are the offenses?
Rejection against the 239.
But henceforth you read and come. I'll adjourn, but read and come. Okay. Adjourn. Okay. Give the memo, sir. Please,
To make one mention. Criminal appeal that was listed in weekly category, my lords, on 27th. Those were left over. Your lordship had directed that will be passed over to the subsequent week. But it's been 2 weeks now that it has been delisted.
Yes, to get it clear.
My lords. Great.
Get ready with the
My lords,
return note and all.
Yes, my lords.
Whenever I'll get the time, I'll pick up.
Yes, my lords.
Okay.
Grateful.
Yes, yeah, examination of NBW.
Okay. Tomorrow. NVW. Tomorrow. Monday. Okay.
Item
So
18
tomorrow means Monday only.
Tomorrow is
18 to 31,
working day.
32 to 38, 39 to 46.
46, my lord.
46, yes.
Paper 2 chapter, my lord. On that.
Let it reach, lordship. The criminal trial has been stalled since 22, lordship.
There is an opposition.
2
You have
chapter
to-
on the personal
No, but-
difficulty, Mr.
But
Barla.
he is opposing. That's the problem. Otherwise, I would have. What personal difficulty?
Mr. Naik Bollam Naik personal difficulty. 2 chapter, my lord.
Convince your brother.
Sorted, lordship. Game already 4 adjournments they have given, lordship. Shorted.
Personal difficulty.
Yes, lordship. Sorted.
Sorted.
Last chance. As a last chance, lordship.
It's made clear that no further adjournment shall be granted. Yes.
47 to 56.
Adult mention possible now, madam.
54.
I pray, madam.
Yes.
One capture one. On behalf of students at Kiaba.
On request. Yes.
57 to 59.
My lord, 58 may kindly be taken next week because I have to file counter, my lord. I am OP number 2, my lord. 58, my lord.
Counter affidavit not yet filed. The opposite counsel for the OB2 seeks one more opportunity to file the counter affidavit. Let him do so within a week. Please, yeah. Yes.
60 to 62. 63 to 66.
Like I mentioned, my lord, weekly list hearing matter, my lord, 98. Today may not be list. Monday, first case after launch, my lord. Process completed. Vigilance case matter already. I have received the paper.
You get ready with the written note and all. If time permits, I'll pick it up.
Monday, my lord, Monday.
Monday only. I'll pick it up. But get ready with the.
Oh, like it. Okay. 98. Weekly list.
You get ready with the written note and on the other side.
Yes, sir.
If you prepare a written note, give the copy.
Everything.
Give the copy to the other side.
Oh, like.
Yes.
Item 1.
Possible.
Item 3.
May I please, your lordship? My lord, the present petitioner is seeking relief 482, my lord. My lord, the present petitioner is falsely entangled in this case only basing on a word that from the local inquiry, this present petitioner, there is a NDPS case, and the present petitioner role is that he is abates the crime or he is supplying the contraband ganja, and he is entangled for the 29 NDPS Act along with one Debendra Niriki. In the meantime, the charge sheet already submitted. All the charge sheeted co-accused person released on bail, and as a part of Debendra Niriki is concerned, he has approached this court in CRLMC 4353 of 24, and your lordship granted, my lord, in para 3, Laden counsel for the 57 submits that on merit as well as on the ground of parity, the petitioner is otherwise entitled for grant of bail. However, she submits that at this stage she would not press this petition, rather the petition would appear surrender before the
You want same order?
mine.
Give it at party.
Oh, mine.
All other accused persons have already been.
Mine.
Right.
This is already mentioned. I am from Mangal Hantal, which is also reflected in the order.
It is Mongol Hotel is the petitioner here. Ye Mongol Hotel is petitioner.
Mine.
Petitioner and one Devendra Nigri.
Niriki.
It's 49, LLMC, 435. Para 2.
Same order. She wants that she should appear in the Sikh bail.
Mine. The
And it will
Debendra,
be decided.
already he is released on bail, Debendra Niriki. Mine. Oh,
Yes. Please put that, yes.
Item 4,
my lord, on behalf of Miss Das, made the matter take after 2 weeks.
2 weeks.
item 5,
May I please? Now, this is the Belgium matter, my lord.
Yes.
NW issued
Yes.
on dated 16/7/2004, my lord.
16/7/2004.
My lord.
Okay.
And another connected matter.
No. You are on bail.
Yes, my lord.
When you got the bail?
My lord. Annexure 2, my lord, page 18.
Tell me the date. You did not give. Tell me the date when you got the bail.
5/9/2003.
5/9/2003. 5/9/2003 and NBW 16/7/2004. ठीक है? You gave 2,000 rupees.
My lord.
2,000.
And another connected matter, my lord. This is for questioning the process of proclamation.
Which item?
5 item.
Sub item. Sub item में कौन आना? बोल दो.
The process of proclamation under section 82-83 service, my lord.
82-83 has already been initiated.
My lord, similar matter. ODA Act 2024.
Petitioner is an accused in so case, and he was on bail. Give the bail date.
My
He
lord,
was admitted to bail on
bail by 5/9/2003.
5/9/2003. And NBW?
NBW, my lord, 16/7/2004. Similar
NBW
matter.
was issued against him on 16/7/2004. Since the petitioner failed to appear, a process under section 82-83 CRPC has also been initiated by the order dated 24/4/2024. At this stage, petitioner is approaching this court and undertakes that he would appear before the court on or before 10th of March. And before to the remedy available to him. Subject to petitioner paying a cost of rupees 2,000 to which bar is this? Sundargarh Bar Association, and appearing before the court, surrendering before the court on or before 10th of March, the execution of NBW the order dated to 28/8/2024 is shall not be executed. Shall not be executed. State 83. I'm saying that proceeding. Let him appear. Okay, appear saying that. Yeah, see. And it is made clear that no extension shall be granted in this matter. I will not give you extension if you move application. I'm making it clear. Yes.
Item 6.
Both the matters discussed. Okay. 6. Yes. Yes, sir. Last one.
Item 7.
Your Lordship, the petitioner is the estranged wife of the OP2 and also the mother of his child. Your Lordship, the FIR by the OP2 is a clear abuse of the process of law.
Husband.
Yes, Your Lordship.
Husband filed an FIR against you.
Yes, Your Lordship.
What are the offences?
Your Lordship, the offences are under section
341, 326 and all.
and 324.
You have beaten your husband.
No, Your Lordship, there is nothing.
Huh?
Your
You
Lordship,
attack your husband by means of knife, then 326 only. Any injury received? An injury?
Your Lordship, simple in nature. Injuries are simple
Maybe
in nature.
323. I'll issue notice. Sort it out. Yes.
Your Lordship, there is a stay application.
Stay of what? What is the stay?
Stay for proceedings before the JMFC.
Oh, no, what is the stage? What is going on there?
Your Lordship, stay regarding the proceedings before the
What is the stage?
stage, Your Lordship, charge sheet has been filed and the investigation is already closed and they have been asked to appear before the JMFC.
No, appear. See, have you ever attempted for settlement?
Your Lordship, settlement has not been attempted for, but I have a anticipatory bail order in my.
Then what is the problem? You can appear. No problem.
But Your Lordship, in the meanwhile.
And what is happening in the marriage front?
Your Lordship, the husband has filed for a divorce.
Divorce.
Yes, Your Lordship.
Then I'll
paying
send
maintenance also.
Mr. Jena. I'll send it for mediation. This will lead nowhere. Huh?
Your Lordship.
I'll send you for mediation and still proceeding.
Your Lordship, there was an attempt for conciliation also, and I have annexed the report.
I know that is before police.
Yes, Your Lordship.
Counseling center, but
Yes.
High Court has a better process.
Yes, Your Lordship. Yes,
I'm sending it. Okay.
yes, sir.
Right. The additions of opposite party number 2, who is the husband of who is husband? Rusikesh Mishra? Husband or Rajiv Panda?
Rajiv Panda, Your Lordship.
Who is Rusikesh?
The brother, Your Lord. The brother-in-law.
Wait. Right. At the instance of opposite party number 2, FIR number so came to be registered against the petitioner. Petitioner is the wife of opposite party number 2. There is the matrimonial dispute has led to filing of a divorce proceeding by the opposite party number 2 against the petitioner. Since this dispute is arising out of a matrimonial discord, I'm of the view that the party should explore the possibility of a settlement through mediation. Hence, the parties are relegated to the High Court mediation. Awaiting mediation report, release the matter on settlement as stay. In the meantime, proceeding before which court, madam?
Your Lordship, the.
Where is it? Okay. State. During the state, during the process of mediation. Yes.
Item 8.
Obliged, Your Lordship.
Give a date after 4 weeks. Yes.
The order of cognizance in NI Act, my lord. Check was dishonored on 28/12/2023. Notice was issued on 2/1/2024, which was insufficient. Thereafter, second was issued on 22/7/2024. Now, on the basis of second notice, cognizance has been taken, my lord.
Which is time bar.
My lord.
Let us see the first notice.
Lordship kindly have the averments, my lord. Page 12 of the complaint petition.
12.
The complainant presented the said check with UCO Bank Sonpur branch where the complainant is having
Where are you reading? 12, which paragraph?
para 1 to 3, my lord. Starting from the word the complainant.
Complainant presented the check. Yes.
Presented
UCO
the
Bank
check said check
so-and-so,
UCO Bank Sonpur branch where the
the bank
complainant
authorized
the bank authority resorting to the due banking procedure returned the check to the complainant on 18/28/2023 with remarks and ground that the check amount could not be from IDBI Bank, that is from the account of the accused due to
page 13.
Page
Part
13,
two.
my lord.
Having no other alternative.
Having no alternative on 2/1/24, the complainant issued statutory notice under section 138B of the NI Act to his advocate to the accused in his correct address under the registered post ID with request to pay the entire amount within 15 days after receipt of the said demand notice.
That
Sent by
is,
registered
could
post.
not be located.
My lord.
Thereafter, the complaint
Complainant inquired.
I am again so.
The advocate for the complaint again on 22/7.
July 2024.
My lord. After 6 months, my lord. More than 6 months. And complaint petition was filed on 12/8 and cognizance has been taken, my
Have you
lord.
moved any application before trial court?
My lord.
You should have moved an application. Why have you not straight away came here?
Because, my lord, the cognizance is barred by law of limitation, my lord.
That's right, but you move an application before the court. It is time barred complaint.
Because
I'll record it and send you to the trial court. Move application. Have an advantage of an order.
Lordship will glance the improved order. It is a mechanical order. What Lordship earlier page on that.
I know the cognizance orders are passed like this. So therefore, the court might not have seen it all. So that's the reason I'm saying at least you move application. Right now. The petitioner is challenging the order dated 24/10/2024, passed by
SDGM Sonpur.
SDGM Sonpur, taking cognizance of offence punishable under section 138 NI Act against him. Mr. Mishra and counsel for the petitioner, taking me to the contents of the complaint, submits that the complainant in his complaint has admitted the fact that initially the fact that the check was dishonored on
28/12.
28/12/2023. He issued a statutory notice under section 138 bracket small b of NI Act on 2/1/2024, which could not be served upon the petitioner and written back with a postal remark that addressee, inverted comma, addressee could not be located. Thereafter, it appears the complainant had issued another notice in July 2024. On the basis of the said notice, the complaint has been filed on 12/8/2024. Hence, Mr. Mishra, counsel for the petitioner, submits that the complaint was not eligible as this was barred under law. However, he submits that on the query from the court, he submits that he had not moved any specific application in this regard before the court below. Hence, he seeks to withdraw the present.
That will prejudice me, my lord. Lordship observe, I will move.
Yes, okay. Therefore, I am not inclined to entertain this petition at this stage. Our liberty is granted to the petitioner to move application before the trial court for dropping the proceeding on the ground as state apart from other ground. With this liberty, the petition is disposed. Yes.
Till consideration application, no further proceeding, my lord. Because
you move application, it will be dropped. Why you are complicating? I have recorded everything. Yes. Yes.
May I please, your lordship, in challenging the entire criminal procedure and cognizance, my lord, on the ground that there is a family dispute between both the sides. Mother lodged FIR against son and other.
But in 307, what have you done?
No, no, cognizance are taken under section deleted.
Where is that order, cognizance order?
26 page 16.
Mother lodged FIR against son and other in-laws of the family members.
323.
Annexer, your lordship may see Annexer 3. Mother, in the meantime, mother died, my lord.
Mother is the complainant.
Mother is the complainant, you died, Annexer 3. Your lordship may see Annexer 3. There is a family dispute.
Who is the complainant?
Mother.
And she died now.
She lost FIR against family due to family dispute.
All family members.
Son and other family members.
I just issue notice, just see, huh? Because mother died. In any case, the complainant died. And mother's complaint against the children.
Children.
Because of the property dispute.
Yes, my lord.
What to do? Yes. Issue notice, Mr. Jena accept notice. Huh? But what to do now? What will you do with this? What is the stage of the trial? What is the stage, sir? You have not.
Trial is not started, my lord.
See, you have not filed anything.
No, Annexer 3 ta file korchi death certificate.
Death certificate is all right, but let us see. Let us see the charge sheet. Who all are the witnesses? Do you have the list of witnesses? Charge sheet. If you have the charge sheet, then I'll just issue notice. Just check it up. If in the charge sheet, if you are heavily relying upon the complainant and there is no other witness, she has died. What will you do? And how can you sustain a conviction? I'll issue notice. Let him get the charge sheet. Place on record the charge sheet and tell me who are the witnesses. I think this is a case to be dropped. Unnecessary. 323 and all. Yes.
My lord, in this case, the present petitions both are the students, my lord. In the meantime, charge sheet filed. In the date of occurrence, the present petitions are not present, my lord. What happened, my lord? The informant.
Where is the charge sheet?
Charge sheet.
Copy charge sheet. Just see. Mana.
Other accused already released on bail, my lord.
Yes.
Charge sheet from Opakar. Separate file is.
What are the allegations in the charge sheet against you? What has come?
Allegation, my lord, what happened?
307 is there. Therefore,
my lord, interesting fact, you can FIR to the Kuji.
Investigation is charge sheet.
My lord, 307 Kuji. In the other students, say that Gorada Hangi, the Pudri, Dada Boti Mage. The informant, husband, Dada. Se ତାଙ୍କର ଆଜ୍ଞା 15ଟା antecedent ଅଛି ତେଣୁ ସେ ଦାଦା ବଟି ମାଗେ ଆ ବାପାକୁ ଦୋକାନରେ ମାଗୁଥିଲେ that is the entire allegation.
And these two people, both of them have attacked this thing.
ଇଏ ଠେଲି ଦେଇଛନ୍ତି ଇଏ ତ ପିଟି ଦେଇଛନ୍ତି ତା ଗୋଡଟା ଭାଙ୍ଗିଥିଲା ଯୋଉ.
Show me the charge sheet. Unless you show me the charge sheet, I can't help it. Right on. Mr. Das, let me for the petitions.
Warrant ହେଇଯାଇଛି ଆଜ୍ଞା.
Needs to file.
Surrender any condition, your lordship. Yes.
And then I'm.
Surrender any condition. Because student of Paranagi.
I know, but student doesn't mean that you will.
Really, no, say enter disease is a victim. See,
cognizance. Where is NBW?
NBW is surrender any condition.
Petitioner by invoking the inherent jurisdiction of this court, seeking quashing of the FIR number so registered against them for alleged commission of offence under section so and so. After investigation, charge sheet has already been filed in the present case, and the trial court by order dated 28/1/2025. Cognizance of offences punishable under section 341, 294, 323, 307, 506, and 34 IPC. The court below has also issued NBW against the present petitioner. Apart from present petitioner. Mr. Das, then accounts for the petitioner submits that he would not be pressing this petition, rather would prefer to surrender before the court and resort to the remedy available to him. On instruction, he submits that his clients would surrender before the court on or before 15th of March.
Other
15th
accused
of,
already religion there.
15th of March so and so, and move application for grant of bail. He further submits that the co-accused persons have already been granted bail, so therefore he is entitled to parity. It is open for the petitioner to urge all the grounds for grant of bail, including the ground of parity. Parity. Till 15th of March so and so, no course of action shall be taken, subject to petitioner
Yes.
appearing.
Yes, ma'am.
Surrendering before the court.
Surrender before.
Surrendering before.
Yes.
Till the date of
Till
death.
death, sir.
It is made clear that no further extension for surrendering will be granted.
Obligement.
15th March, till 15th March I have given.
Obliged.
Go and appear and get.
Yes, ma'am.
They are students.
Co-accused already religion there.
Yes. That I have recorded.
Yes.
This put. Yes.
11.
Lordship, in this case, the proceeding under the PMLA is being impugned on the ground that no sanction for prosecution under section 197 of the CRPC has been obtained.
For the schedule offense.
The scheduled offense is 13(1)(e) of the Prevention of Corruption
No,
Act.
if for schedule offense you required, for a PML.
No, for the PMLA also, there is a latest decision of the Honorable Apex Court, which says that for the PMLA,
Have they taken?
yes, in the scheduled offense, charge has not yet been submitted.
Independent sanction is required for PML.
Yes, yes, Lordship, may kindly go through this.
Because that if the offense is connected with the official duty, then the against.
PMLA proceedings are consequential proceedings. Consequential proceedings.
Hey, one minute, one minute.
It is a
Let me
consequential
submit.
proceeding.
Let me submit.
In the schedule of
Lordship,
it is sanctioned.
Lordship, in this reported decision,
Show me the paragraph.
this is also
Which paragraph?
the first, the factual matrix, Lordship, may kindly come to the factual matrix of the case. Para 2, it starts. He pointed out that the assertion para 3 made in the complaint that at the relevant time, the first respondent was the vice chairman and managing director of Andhra Pradesh Industrial Infrastructure Corporation Limited, for short the corporation. His submission is that he was not a public servant. Lordship, not this, the consideration of the submission I am pointing out. Then the law has been.
Yes, come to pay para 70.
Lordship,
60,
Lordship.
60, 17, straight away. Direct judgment. Direct judgment.
Not direct. Your lordship will go through the next paragraph.
17.
No, I will.
That paragraph.
Therefore, we hold that the provision of section 197(1) of the CRPC are applicable to the complaint under section
Lordship,
44 on the
One minute, one minute. Let me submit. Let me
I
submit.
got it.
Lordship, what has happened in this case? They were public servants. They are being prosecuted for the offense under the Prevention of Corruption Act. And mine is an offense which can be committed only by a public servant, intimately connected to the office. This offense cannot be committed by any other person other than a public servant.
Your
What is the
lordship-
distinction?
Your lordship kindly see the trial court has referred that because I.
No, come to para
That
18 of
judgment has
the
been quoted below at page 26.
26.
The trial court has wrongly appreciated. That is my grievance.
Let us 26.
You just supply me a copy of the judgment. Right now I'll point out. Supply me a copy.
Copy is there in the petition, sir.
It's judgment copy.
Oh, judgment.
Yeah.
You take.
Your lordship,
Yeah.
page 36, last para.
36, that's para. Yes.
In the same case, the trial court has taken note below. The Hon'Ble Court held that the protection under 197 CRPC has certain limits and is available only when the alleged act done by the public servant is reasonably connected with the discharge of his official duty.
Which
Or
paragraph
not
is it?
merely block for doing the objectionable act. Section 197 CRPC does not get immediately attracted on institution of the complaint case.
No,
It's
I
a
think
very clear judgment.
I think non-application after the judgment.
It's a
Yes,
very clear
Lord.
I'll
judgment.
just pass it over. Just
Yes, my lord. Your lordship pass
pass
it.
it over. Just give it. And
That-
give a copy.
that-
Mu doichi copy.
Item କେତେ ଲେଟା?
I am giving the copy.
11.
I have.
Your lordship take it up after lunch मिलो
after lunch ମୁଁ ଟିକେ ରହିବି ନାହିଁ
ना बात करो
ନାଇଁ 8ଟା ବେଳକୁ ମୁଁ ଭୁବନେଶ୍ୱରରେ ମୋର ଗୋଟେ ଆର୍ଗୁମେଣ୍ଟ ଅଛି I will go. Lordship may fix it to any other date.
Monday
It is
asu,
fixed
Monday
to
asu.
20th for framing of charge.
Monday asu,
Tuesday,
I am
On
not
that
seeking
date,
time.
it will
I
be
am not
adjourned.
seeking time.
And then any other.
Tuesday.
Monday
Tuesday.
take convenient to my lord.
And come at 12 o'clock. This is
Yeah.
small matter.
Tuesday.
Yes.
Tuesday is which date?
18.
18th, yes, yes,
18th.
yes, yes.
Yes.
On 20th it is there.
Yes. 18.
No problem.
Okay. Keep it, huh? That matter. Yes.
Item 12.
What is taken?
Item number 12. On behalf of the counsel appearing for the victim, there's not one pass over, Your Lordship.
Pass over. Oh. Okay.
Hello, the petitioner has been charged under section 376 and section 4 of POCSO Act.
Then,
But Your Lordship may see the
on the ground of compromise, you want to
Your
let it
Lordship.
pass?
Yes, Your Lordship.
Not possible.
My lords, the victim has deposed an affidavit which has been annexed, Your Lordship.
No, what is the stage of the trial?
My lords, 80 to 83, the proclamation.
That's the problem. I'll see. What I'll do is I'll pass that 80 to 83 proceeding and go and appear before the court. And if the girl is supporting you today,
Let's let the counsel appear.
No,
Lordship.
this is a proposition. If the
Lordship.
girl is supporting you, and I'll direct the trial court to record the statement of the girl first.
My lords.
And if you see result out of her statement, you are out. Because he has already implicated you in 164.
My lords.
Because of the judgment, I can't help it. This much I can do. Think over. Think over. I'm just passing it over.
Lordship.
Yes.
Obliged.
Item 13.
This is that same FIR of that industry by another person. Your Lordship, 144 was there and there was a congregation, my lord. Your Lordship said passed an order.
Where is that?
This is the 5th FIR. 4 your Lordships have passed orders.
Okay.
So only 2 difference, my lord. Here your Lordship sees I have made corrections. The incident your Lordships have recorded in this case is 12 p.m. and here it is 4 p.m.
What is this 13 days?
13 days is what your Lordships gave me protection on the first order.
Okay.
So only those 2 changes, my lord, and this will be tagged with that case.
So same order I'll pass.
Same order. Here,
Same
my lord,
order tag, huh?
in
Same
that
order tag.
case, the
But now I'll give the date up till 15th of March.
Lordship pleases.
15th of March.
One more, my lords. Their OP number 2 had appeared. If your Lordship sees the first page of the order, that Minakshi Prushti had appeared. Minakshi Purti, OP number 2.
Yes.
Here notice will go.
In the first paragraph,
Again.
the Kaviraj Pradhan advocate is entered.
Last time he had appeared.
But here notice has
Also notice has
issue
to go.
notice to opposite party number 2.
Yes.
Thereafter, first paragraph issue notice to also. And the last page would achi taku kordavo
15th March.
15th of March korbe. ठीक है?
Grateful.
15th March कर दो, same order करी tag करो. 2025, ठीक है? Same order करी tag कर दो. ऐसे tag करो, ठीक है? Okay. Okay. Urgent tag होगा ना? That's it. Yes.
40.
May I please your Honor?
Yes.
My lord, this here, my lord, a notice has been issued under section 126 of the BNS. Your lordship may kindly see that is the annexure 1. Page 8 is the notice and annexure page 9 the neat copy I have.
Yes.
My lord, I was asked to show when a cyclostyle copy that a complaint has been received from Lingaraj police station and you show cause why bond. But no substances of allegation, nothing. On what basis I will give you my show cause. And your lordship may see the original at page 8, a cyclostyle copy. I am my lord, a homemaker, a housewife, aged about 60 years. Though I am not aware of the allegation, but my lord, there was some dispute between
Nothing was attached to this.
Nothing was attached. And my lord,
Yes, so this is
and
you have to furnish bond or personal bond.
absolutely nothing, my lord. No allegation. The section 129, your lordship may kindly see. He has to record the substance of the allegation.
I know, but that's right.
Absolutely nothing. And my lord, what happened, my lord, I am just telling you, your lordship. My lord, my brothers, 2 brothers, elder brother and younger brother, there is a property at Tankapani Road.
valuing 4 crores, my lord. Without our knowledge, forging our signature in a national local, they said that we have entered into a compromise, they got a compromise decree, my lord. Later on, when we came to know, we challenged that order before this honorable court in a writ petition. The writ petition, your lordship has
Then what I'll do is I'll direct the who has issued this notice.
DCP, additional DCP.
I'll direct him to supply the copy. Thereafter only you will go and defend.
Let it be stated. My lord, he is a lady, my lord.
Obviously, I'll say it and I'll ask him to, because due process has to be followed. Your grievance is correct.
Your lordship may call for the record. What is the alias?
I'll dispose it up. The copy.
Let it be. Let notice be issued and let me record.
Why unnecessary?
My lord, kindly see. They will insist because I know what has happened, my lord. My brother have some hand in those with those people. They have because I made a complaint that they are violating the honorable court's order with the injunction the status quo order. They have done this. That 100 and my writ petition.
I don't know. Nothing is there before me.
Absolutely nothing.
Except this notice. Except nothing is
what
there.
I'm apprehending that my brother might have done all these things.
See, I can't pass an order on the basis of might have.
Your lordship simply issue notice, state proceeding and let him get the record. Your lordship may see the record there.
Then it will be pending for 16, 17 years.
No.
And after my retirement, it will come. That's the problem.
My lord,
I will dispose up and with all the relief which you are seeking. Dispose it up. I'm saying that I'll say it. This will not be executed unless the entire record is supplied to, entire complaint is supplied.
Let him make a fact-finding inquiry, my lord.
Let him do whatever. I will not guide it. But what I'll say is this notice discloses nothing.
Set aside
and supply the copy and proceed. If at all any complaint.
If there is any.
Instead of saying it, I'll set aside. And
again they will ask me.
Then you will know what are the allegations. Your only grievance is a notice has been issued without intimating you. Why for? Nothing is.
Absolutely nothing. Your lordship,
I'll set aside.
Your lordship, there are judgments, my lord.
You are seeking for set aside. I'll set aside.
Let him please.
No, I'll set aside.
Well, let it be.
You are asking for stay, I'll set aside.
This order will pass after some days. Let it be stayed for the time.
What do you say?
Order is there. Nothing brief also.
He should know why for this notice.
Let it be stayed.
Actually, generally, with along the notice that complaint comes. He said that the complaint has not come. So what I was proposing is I'll set aside.
Let the
due process.
At least your lordship will do it in the next date.
Okay. Issue notice. Written also. In the meantime, the notice dated so
that CMC number already there.
CMC so is state only state because Mr. Acharya Land Council for the petitioner submits that barring this notice, no other documents have been supplied to him. His client is clueless as to why the said notice has been issued in the absence of any ground for which he has been the petitioner has been sought to furnish the bond. The notice cannot be executed. Hence, the internal the notice is stayed. At least the matter good week for the youth fourth.
Not before 4th or after 10th, my lord. Because 4th to 8th I will be absent.
Then I'll give it on 12th. Okay.
12th of April.
12th of March. Yes.
12th of March.
12th.
15.
Now here the appellant convicted under section 7
of copy of the order.
Yes.
Mr. Acharya, in lieu of setting aside orders, prefers interim orders. That's a good piece of order.
He wants 50% relief. He doesn't want 100% relief. That's the problem.
Well,
I was telling him to set aside, and he says, no, I need only 50%.
That's a rare proposition, Mr. Acharya.
Yes.
Regular
simple imprisonment for 3 years.
3 years.
Okay. Same order. Okay. Admit them because that's appearance enough. Yes.
My lord, that bail and the stay realization fine. Stay realization fine and bail also.
Those things are already granted. You don't want, then I'll think over. Yeah.
17.
Belgium, my lord. Warrant was issued, my lord, on 2/8/2024. It was on there. Saturday, 21/11/2015.
Okay, 500. Yes.
18.
16 urgent, right?
16 urgent. Yes.
May I please, may I please, my lord? Here, my lord,
What do you
Belgium
want?
case, my lord.
16. Okay, he sought adjournment. No? You sought adjournment. Now you prepare and came. And Mr. Das is ready to argue. If you want to argue, then
My senior will argue.
yes, on the or request. Okay.
Internodal control.
Internodal.
Sir, my lord, on 3/1/2025, NBW has been issued, my lord. And the petitioner was on bail, my lord, on 16/11/22.
16/11/22,
my lord.
22. NBW?
My lord, 3/1/25.
25.
My lord.
Okay. Yes.
19.
19.
NBW order 23/7/2024, earlier bail order 29/2019.
Give the dates.
29th January bail. 23 July 2024 NBW.
Okay. 500. Yes.
20.
28/11/2023 bail. 9/10/2024 NBW.
Okay. 500.
I have a simple prayer, my lord, that warrant has been issued on the date of delivery of judgment. And co-accused has been sentenced 1 year maximum sentence in the case. So may I pray, my lord, when I will appear and
1 year sentence 389.
That's I pray, my lord, that the magistrate may follow that 389.
Oh, the statutory provision he has to follow. If the sentence is less than 3 years, he has to give the protection.
Since NBW was issued against another accused,
no, I am causing it.
He's sentenced to forwarded to custody, my lord.
How can he forward to custody?
Since the warrant
if the sentence
was
is less than 3 years,
since the warrant
benefit has to be given to you.
Kindly order date page 18, my.
Which item?
Item
20.
Page 18, my.
18.
Yeah, my lord.
Yes. Yes.
Learned magistrate has explained 389(3).
18 and 8/11/2020.
18, my lord.
Yes. Yes.
In past para, my lord, provision of 389(3) was explained.
Where are you reading? Oh, sorry. Yes. Letter.
My lord.
The case record is put off letter for hearing.
So
and
another accused forwarded to custody. Since warrant also.
Neither the convicts are not the complaint of fiction judgment and no steps taken. We have
If your lordship was the NBW, then it will not.
Surrender before the court and the judgment is open and pronounced from provisions of 389(1) of the case. The boy has to submit to shall with leave to the brief and the bail if satisfies the convict was and bail. Convinced in sentence to imprisonment for a term of then one says that if the convict was on bail, he has to be given bail.
Yes. Then if your lordship quash the NBW, then there will be no.
I'll quash it.
Mine.
I'm quashing it.
Mine.
And this is completely absurd, the order.
That's why I am praying before your lordship.
No. What happened is the convict didn't go to the court when the judgment was pronounced. It was put in seal cover. NBW was issued. He went and appeared once. The seal cover was opened. Though 1 year sentence is there, he was sent to custody.
Should I?
Saying 389(1) bars. 389(1) says that if he is on bail, he has to be granted bail.
And the sentence is maximum 3 years.
3 years. This is completely wrong order.
That's why.
Absolutely. So what should I do? I will quash the NBW then.
Quash the
right up. Quash the NBW quash the and we it has to be no wrong should be done. Mr. Pandar, the counsel for the petitioner submits that submits that in case of co-accused, in case of the co-accused, the court below has remanded him to judicial custody despite the sentence awarded to him is maximum 1 year. 1 year. 1 year. 1 year. He has pointed out from the proceeding that by misconstruing the provision of 389 bracket small I, the co-accused has been remanded to custody despite the sentence is only for 1 year. 1 year. He apprehends that even if he surrenders before the court, he may not be given the benefit of the 389 KRPC. The provision of 389 KRPC is very clear, and there is no scope of the misinterpreting the same, misinterpreting the same, and hence the apprehension of the petitioner that he may be remanded to judicial custody once he surrenders the unfounded. Regarding that, the aforementioned, the NBW issued on so and so its class. The petitioner is directed to appear before the court and so on. I've recorded that so that at least I will not be sent to custody.
I will get that.
Yes.
21.
My lord, order number 91, 22/2023 NBL order, bail order, my lord, 2715, petition number 1, petition number 2, my lord.
Yes.
Tell the dates.
19/6/2015 बेल 22/02/2023
Okay.
NBW
500 each. Yes.
22.
27/2/2018 my lord bail order my lord and NBW my lord
27/5/2022
Okay.
27/5/22
22 na?
My lord.
Okay. 500. Yes.
23.
23
Maybe. Order dated 17/11/2020, page 24, my lord. NBW issue.
Yes.
my lord 17/11/2020 to 10/1/2025 the accused person is absent absconder declared
All
absent
co-accused were released on bail.
No, he was not on bail.
not on bail
First or second parity.
No. You, just surrender and resort to the remedy.
Yes, ma'am.
NBW issued on 70 absconder.
yes
Petitioner is stated to be in absconder. Therefore, the NBW has been issued on 17/11/2020. Same order. Yes.
24.
My lord, NBL order 9/5/2024 and LR bail order 14/11/2023, my lord.
Give the dates.
14/11/2023 बेल 9/5/2024
Okay, 500. Yes.
25.
21/12/2021 बेल 9/12/2024
Yes, my friend.
500. Yes.
26.
24, sir.
Huh?
24 one NBW. 9/12/2024.
24, 500. You want to pay more than. It can't be less than 500 at least. And since you are appearing, it should be at least increased. Make it 1,000.
Yes.
1,000.
My lord, 23, my lord.
22/9/2015 bail and NBW 16/5/2018.
18.
My lord.
1,000. Yes.
Obliged.
58.
28. Service 20% yours? Flag A. There is no flag M. Flag M, huh? Order. Six-month time is short. Yes. What is this matrix? Oh, there is what is that order? It's referring to some order. That order is not there. Order number 7. Where is the order number 7? It's not uploaded. 12/7/2024 order. 12/7/2024. Where is that one? Get that order. 12/7/2024. Huh? Password. Huh? Get that order. Huh? Because nobody will come. This is a letter by the tribunal. I have to extend the time. Get that order. What is that order? Huh? Yes, password. Next.
29.
Please, Your Lordships. Here,
Yes,
I
sir.
filed the application for restoration of the writ, my lord. It was dismissed for default, though I was appeared, but on the date fixed, my name was not reflected in the cause list, my lord. Therefore, I could not see the.
Is there anything on merits in the writ petition?
There is no such merit, my lord. But I will hear on merit. Let it restore, my lord. Let it
No, I'll restore it. But do you have anything on merits in the writ petition? Otherwise, why?
Yes, my lord. That's some merit because
it survives any cause.
Yes, my lord.
What have you asked in that writ petition?
My lord, correction of parlor, which has been wrongly recorded in the name of prosecutor.
Mutation appeal and all. Yes. For the reasons stated in the application, the same is allowed. The writ petition number so and so is restored to its original file. Please the writ petition for hearing before the appropriate bench. Yes.
30.
Yes, sir.
Last submission that I filed two applications. There's one for substitution methods and the other one is publication, paper publication.
Yes.
One to take IE 91 methods.
91?
Methods.
Okay.
That's under order 5/22 because opposite party number 5 is opposite party number methods. 1, 2, 3, 6, 8, 10, 11, 14, 15, 16, against whom the notices are written unserved.
Yes.
Because the addresses would not be sent completely by the petitioners. I've prayed for paper publication under this interim application.
Yes.
Vis-a-vis those opposite parties members, if one can commit, I will initiate paper publication for the service of notice.
No, against which respondent?
Against opposite party number
1, 1, 2, 3,
my lords,
6, 8, 10,
my lords,
11, 14, 15, and 16.
my lords.
What about 17? 17 also.
My lords.
7 also.
My lords, my lords. My lords, against 7 my lords. 7 also it is written as insufficient. I'll take against 7.
So then 1, 2, 3, 6, 7, 8,
10,
10, 11, 14, 15, 16, and 17. You right. The service on these respondents were not sufficient. Therefore, the present application has been moved to serve them by submission, serve them by publication. Let the petitioner take the appropriate step to serve the said respondent through paper publication, publish into one local and one national. Yes, allowed. Next, 92.
My lords, opposite party number 5, 12, and 13 my lords. The noting is that they are dead my lords.
5, 12, and 13.
My lords.
5, 12, and 13.
My lords, vis-a-vis opposite party number 13 my lords. Opposite party number 13 has died unmarried. And there is no right to sue does not survive vis-a-vis opposite party number 13.
The petitioner has moved an application for bringing LRs up to 5, opposite party number 5, 12, 13 on record. And the conservative petitioner submits that the PAP respondent number 13 has no legal heads. Hence, opposite party number 5 and 12 he is pressing the application. The application, for the reason stated in the application, the same is allowed. The LR of 5 and 12 shall be implemented as respondents and no party file, and the first steps to be taken to serve these witnesses. Yes.
Sorry, my lord. Item 13, my lord.
Item
Item 13, my lord.
13 pass over whatever in between, huh?
My lord, I'm appearing on behalf of the opposite party member. Notice, Mr. Polisa, my lord.
Where are you?
I'm
item 30 now.
Because I cannot.
Oh, the wait then. Wait and mention it when. Then are you appealing? First paragraph, please. First paragraph. Okay. I'll change that. Okay.
All right.
Your appearance I'll mark.
In course of the day.
Yes.
31.
I am from the opposite party.
Yes.
It's a review against the judgment passed by this honorable court. They
Yes,
want to.
You are for opposite party.
Yes,
Who is appearing for the petitioner? Yes, madam. You are not. Who is appearing?
Last occasion, now your lordship will see, it was heard substantially, then they took 2 adjournments. By showing this review, the execution case is not proceeding because they have filed an IA for stay of execution. They are showing that it is pending in High Court. Your lordship may clarify that the execution proceed will, because there is no stay by your lordship.
I'll pass it over. Let us see. If it can be disposed of, it can be disposed of. Nothing is there in this matter.
Well, can it be before lunch? My 2 associates are getting married. So can it be before lunch, before your lordship rises? And I know it's undue request, my lord. I just want to. If
The marriage of juniors, you must go.
that is the problem. Both are with me.
Okay, 12 o'clock.
12. Great.
But the problem is, so I generally take it 2 o'clock.
Yes, my lord.
If I take it at, who is the counsel? You just tell him.
Mr. Santosh.
You just call him and tell that 12 o'clock it will be taken up.
I'll try because.
Otherwise, shall I adjourn it to next week?
Lordship may adjourn, but your lordship may clarify that the execution process.
Next week I'll dispose it up. What are you talking about clarification? The review petition, why should it be pending?
Next file.
No, Wednesday. Thursday. Thursday.
No, 21st. Thursday there are election matters are there.
Okay.
I
have a DV there.
Yes, yes, fine.
Yes.
That cannot be changed.
Yes.
I can adjust.
Therefore, yes.
Your lordship may say none appears for the petitioner.
None appears for the petitioner, and Mr. Bose, learned counsel for the petitioner, submits that due to the pendency of the present petition, present review petition, the execution proceeding pending before the court below is being adjourned time to time. Therefore, he seeks a clarification regarding the same. Leaves the matter on shown. I record it.
We see one of every other seers. That is the problem.
Yes.
32.
Item 32, my I am in VC, my lord.
Yes.
Here, my lord, the prayer for restoration is there, my lord. It was dismissed for default, my lord. CRLMC.
Any delay?
My lord, there is some delay. Notice was issued. My lord,
292 days delay.
My lord,
Yes.
my lord.
Are you opposing?
My associate, my lord. My associate, my lord.
And I have not issued notice, or have you?
No, my lord, notice was issued, my lord. It could not be solved, my lord. Your lordship on the other day directed me to solve, my lord, the advocate appearing in the court below, but the advocate is not receiving the notice. So I pray, let the notice be solved to the court below by the registry, so that it can be solved, my lord.
Oh, it is private dispute. You have to serve notice.
My lord,
Why should the court be?
Notice was issued through post, my lord. It was not solved, my lord. Thereafter, your lordship was pleased to
Take dusty and serve. Take dusty and serve.
My lord, I took the dusty, but he refused, my lord. The advocate, your lordship may kindly see the order, last order. The advocate in the trial court, he refused to receive the notice. So therefore, my humble submission, if it can be solved through the court, then it can solve the matter is posted to 19th in the court below. So it can be solved through the court, my lord.
No, what are you seeking for restoration? You just let us see. Restoration of what?
CRLMC, my lord.
CRLMC. What? What are you seeking?
My lord, I was challenging the cognizance order.
What are you seeking in CRLMC? Is there anything left in that matter?
Yes, my lord. My lord, he took the, my brother took the money. He forcibly took the check from me. I am not liable to pay the check amount. My brother is absconding, my lord. And I have been unnecessarily dragged into the litigation for NI Act case, my lord.
Okay. Mr. Rao, and counsel for the petitioner submits that despite his efforts, the service on opposite party number could not be effected in the last date of hearing. Even on the basis of the direction of this court, he attempted to serve the opposite party through the counsel appearing before the trial court. However, the counsel appearing for the opposite party in trial court refused to accept the notice. Hence, he submits that let the notice be served through the trial court. Trial court when the matter is taken up, when the taken up. He further submits that the before the trial court, the complaint case is listed for hearing on 19th of
February.
Let the notice on opposite party number 2 be served to the trial court on 19th. So, yes. Please the matter. Next, please.
My lord,
Yes.
Your lordship may fix it.
Yes.
Obliged, my lord. Deeply obliged.
33.
33, my lord. Application for restoration. Here, my lord, it's a transfer brief, so I could not take step for which it has been.
Notice was issued. 338 days.
Yes.
Okay.
338 days.
Notice was issued earlier. Issue notice on the IA number 25 of 2024 and the CRLMH. Written in good source. Yes.
Within 1 week?
Fine. Yes.
Is an application for restoration, madam.
Yes, sir.
The retyping the
How much delay you tell me?
delay is about 2 years.
That's the problem.
14/11.
And take out notice to the
On the yes.
Take out notice on application for condonation of delay.
But I will serve copies on the council for the endowments, madam, because they are the contesting party.
Okay. And no, private.
They are the pro forma opposite party. They are no more.
Sure.
Yes.
At your risk.
Yes.
At your risk.
Madam.
Mr. Dhar, learned counsel for the petitioner submits that the contesting parties are respondent number 1 and 2 and 2, 3 to 13 are pro forma respondents. Issue notice to opposite party number 1 and 2. 1 and 2 on the application for condonation of delay and the CRLMP. So, yes, written will have.
35.
May it be your lordship. My lord, petitioner filed this application, my lord, for modification. Now he is in custody, and your lordship, by order dated 19/9/2024, by annexure 1, page 5. Your lordship was pleased to allow the bail application of the present petitioner by imposing some sort of condition.
What are the conditions?
Condition page 7.
Yes.
Page 7, that is IV. That he shall be released on bail subject to verification of similar type of antecedent. So that is the condition. So that he was on, he is in custody, and my lord, after that 2 cases he has already been remanded, and at present his bail applications was rejected by your lordship. I have annexed in annexure page 9, my lord, that his bail applications was also rejected by your lordship.
Then what do you want?
That at present, my lord, in that case he is in custody. So, but my lord, in the first order, that your lordship was pleased to.
By the way, these matters has to go to the regular roster bench.
Modification टा आगे खाली से जो condition टा आगे antecedent similar type of तार आगे अच्छी आगे तीनटा case जो थोड़ी your lordship was pleased to reject the bail application.
Then I can't help it now. You tell me. How will you get out of 37? I told you to research and come. 37 second bar. Prima facie case is one and second one.
Yes.
How will you get out of?
My lord, but your lordship was allowed the bail application on the ground that 50 kg of
That you merit you have, but
Yes.
antecedent the second limb of 37. How will you get over?
No, antecedent, my lord, to another.
Then I'll reject it. What to do?
My lord, to another cases.
You have to come out with some the facts. Everybody knows the fact. Prima facie you have case 50 gram. I have granted the bail. On merit you have no problem. But 37 bar, how will you get over the 37 bar?
Yes, my lord. ठीक है इसमें out करें. Again, my lord, I pray for some time.
Simply urgent.
I want to set.
Come on,
Yes,
judgment or
authority.
something so that I can.
Authority, my lord.
Yes.
Same in
And
manner.
सब item टा भी मध्य से तार होगी गोटे antecedent.
Urgent করে।
36.
36. এটা কোনো পাই কি?
I pray for my lord next week.
We'll see. He will give a date. Yes.
My lord, extension of time, your lordship was pleased to grant me bail, interim bail on 23/12/2022 for 8 weeks. On the ground that the
No, extension on what ground?
extension, my lord, at that point of time, on the ground of advanced stage of pregnancy, your lordship was pleased to grant bail. On 28, she gave birth to a child. The son is right now, I have stated, he is suffering from acute bronchopneumonia. That is, I have also.
All the children suffer like this.
My lord?
All the children generally.
But. whichever-
Yes, madam.
Yes, my lordship, the medical.
How much you want now?
Another 2 months, your lordship may consider.
Yes.
Child is now.
What are the offences?
Offences totally QC and your lordship.
Antecedents, antecedent.
Antecedent is your lordship may kindly talk to your lordship's order dated.
No, antecedent, you tell me how many cases you have.
Antecedent.
Because in the garb of interim, you keep on, no, antecedent. Okay. For the reasons stated in the application, 211. The reasons stated in the application, the interim bail granted on
23/12/2024.
2024 is extended for further period of 6 weeks. For the period of 6 weeks. Yes. Yes.
37.
May I please? Last time I was kind enough to issue notice to the opposite party.
Yes.
And it's a case where my lord, during teenage, they developed the relationship. Subsequently, my lord, she has filed the FIR. And during my lord, the course of hearing, my lord, she has also got married to the present petitioner. That is page 11.
Yes.
And thereafter, my lord, I filed application on 311. My lord, during that particular period, as it was rejected, I approached the Honorable Court.
They are married.
Yes, married. Page 11. Before the marriage officer, not before any other person. Registered.
What is? Huh? Third. Service. Huh? Through IIC, what happened? Entry mode to continue, service is not complete. Time will heal in these kind of cases.
Yes.
So let it continue like this. Because they are married, what to do? Because of that judgment, otherwise, straight away I would have passed.
Long time, maybe give it. Say
Particularly if the accused is married,
8 weeks after.
they were in relationship. Where the young feel this, see the 20-year-old boy and the
And they will pay to the child, my lord. I'm also
the child.
I'm also running after her that solve this.
These are not the actually cases of sexual exploitation. These are the adolescent law affairs.
And taking advantage of the law of the land, my lord, they are now.
And this act is the Foxo Act was not aimed at that. It was only for the exploitation part where the man is very senior and a child is exploited. That is the act.
Legislature at the relevant time. But
And the same age group children, they get involved, they marry, they don't realize all these things. This is the we have to protect this kind of. It's very dangerous in this society. Yes. Interim order to continue, interim stay, to continue. The service on opposite party number 2 is not affected. Hence, time sought by the State Council to effect service through IO. Lease the matter and so on. So, interim order to continue.
After a long period, 10 weeks after.
Give a longer.
Thirty-eight.
38 minutes, you should see the mediation report. It's flag N. The
Flag
mediation
M.
Flag N minutes. N.
Successful.
Successful.
Very good. Where the other side?
The other side is not here.
I'll pass it over. Huh? I'll
Yes,
discuss that
Lordship will
today.
pass it.
What is the terms of settlement?
But the terms of settlement is that I'm placing my I persuaded and generated several options to both the parties of the process of mediation. The parties are agreed to settle the dispute amicably by resolving the dispute for all times to come. Both the parties are agreed that they will not disturb each other in future and they'll lead their individual life peacefully without into the life of each other.
What else you need? What are the offenses?
The offense was 506.
What are the allegations by the?
Well, the allegation was with respect to a parking place which was being used by.
I'll just pass over and the terms of settlement mediation.
Lot will pass over. I'll try to contact
Yes.
to the council.
39.
Yes. 39. Huh?
Yeah.
Always visit address home, but no person responded this. Knocking the door, no helpful respondent. It cannot be located.
Cannot be located. IIC through IIC report. No, this is postal report. Postal report. No, what IIC says, there is no direction for the notice on opposite party number 2 could not be served through the usual process. Hence, the IIC so and so is directed to serve opposite party number 2 and furnish a report. Yes. Yes.
40.
I am from the petitioner Praveen Kumar Das. Petitioner has been falsely implicated under section 366, 366A, 380 and 34 IPC. On dated 24/4/2003, date of occurrence against informant FIR करथिले आ भितरे लर्निंग सिमिलर फुटिंग रे आउ जने एक्यूज्ड को शशिकांत सर बाइड एनेक्सर 5 रे क्वास करचंती आउ ये प्रेजेंट एक्यूज्ड इज सेम फुटिंग सो योर ऑनर प्लीज काइंडली क्वास द FIR आउ इन्फॉर्मेंट
Notice was issued.
अच्छा इन्फॉर्मेंट तरफ से FIR करचंती
My lord, may I please, my lord? I am referring on behalf of the complainant Dilip Kumar. Obedience to the direction of I am appealing on behalf of the complainant.
Sorry.
Dilip Kumar.
Sorry, what are you saying?
I am appealing on behalf of the complainant Dilip Kumar.
That I understand. What is your submission?
The complainant has no objection if the relief sought for by the petitioner is allowed. The complainant in the meantime has settlement. There has been already a
What the offenses? You file an affidavit from who is the victim?
Right. The complainant. Right
No,
now.
no. You are the informant. Informant is the father. Okay, father of the victim. Who is the victim?
The victim is the daughter of the complainant.
Oh, then victim has to have to implead victim also.
The complainant.
Yes. Complainant may be victim. You implead victim and file affidavit for both of them. Okay, victim and as well as the informant. Okay.
My lord, the victim is
And about the-
my lord, the victim is malnourished and she is staying in a far off place. And on last occasion, in a similar situation, the other accused, in case of other accused, the person was passed on the.
You file affidavit stating all these things.
Lordship,
You
Lordship,
file affidavit.
Yes, right now I'm filing the affidavits.
Yes, you file the affidavit, then we'll examine it. Okay. So and so entered appearance. What is the Mr. Padi? You are Mr. Padi or Mr. Barik?
Yes, my lord, I am Mr. Barik.
Barik, okay. Mr. B. Barik, learned counsel, has entered appearance for opposite party number 2 and submits that he has no objection if the relief sought from the petitioner is granted. He further submits that he would be filing affidavit in this regard. Let him do so within a week. Please the matter after. Yes.
I has been filed for modification of order, my lord. Instead of a city case, GR case have been mentioned, my lord.
City case?
My lord. GR case may be corrected as city, my lord.
GR case to be corrected as a city case, huh?
My lord.
In the prayer, what have you written, sir?
My lord, learned court below has supplied the certificate copy. There is some that error has been occurred in that.
So then you have to get it corrected there, not here. See the prayer. See the prayer. In your prayer, you have written GR case number 3072 of 2019. On that basis, I have done it. In the end, your entire petition, you have said the same thing. Right from the first page. What to do?
My lord, the learned court below has supplied the certificate copy.
I understand, sir. Then you have to correct there. The order is correct. Because in your petition, you have written that GR case number 3072.
My lord.
And the document which you have filed, there also
there is some.
So on that basis, I pass the order.
My lord.
If you want correction, then those things has to be corrected. My order is correct. Unless you correct those things, I can't correct my order.
Well, after correction.
After correction, you can very well move. I will just simply adjourn it, correct it and place it so that I will record it and correct the order. You follow what I'm saying? So correct that first. I've simply adjourned it. Okay. 3 weeks work. Okay. Meanwhile, you correct it and tell me. And bring that certificate copy, place it so that on that basis I'll correct it. Okay.
Can you take up next week?
Within next week, if you can do it, very well do it. 2 weeks per
2 weeks.
I don't think you can do it. Yes. Yes.
42.
Service. Postal stamp shortage. The notice on opposite party number 2 could not be served because the postal stamp affixed for this purpose was shortage, false shortage, and the counsel for the petitioner seeks 1 week time to take appropriate step to cure the defect. Please the matter. Yes.
43.
Do it immediately, sir. Yes. 43.
Although today it is fixed for, we'll say settled 498 matter. Because of some personal difficulty, she is not in a position. Madam, may keep it or coming
498.
Again, coming Thursday, Madam, may keep it on 20th, madam.
Okay. 20th, huh?
44.
44 and also I'm appearing for the petition.
This is 2 p.m.
Yes. There's some problem. That's why it's inconvenient.
44, I'm appearing for the petitions of Lordship. I'm appearing on behalf of Shweta Senapati, Ms. Shweta Senapati. Lordship, in this case, the petitioner has filed this instance ERLMC for treating the FIR, impugned FIR, which is at annexure number 1, page 19, as the subsequent 161 and 162 statement to be recorded, because the Lordship, if I may be allowed.
To treat the FIR filed against the petitioner is a
petitioner is a petitioner is the managing director of a builder company, of a construction company, and this FIR is with relation to one of the projects which was being undertaken by the builder, the petitioner in this case. Lordship, in that case, what has happened is there has been multiple FIRs by different individuals who have filed the FIR against the petitioner for non-delivery of the flat. There are multiple FIRs which are ranging from 2018 till date. And in fact, Your Lordship, in this case, the petitioner is a RERA compliant builder. And one of the persons who had booked a flat in the petitioner's project, they had moved the RERA court. The learned RERA court had also exercised their jurisdiction, and subsequently they had also ordered the petitioner builder to deliver the possession of the flat to the complainant. Therefore, Lordship, my humble prayer is that since there is a specific statute for non-compliance of timelines and non-compliance of activities by builders, the petitioner may be the subsequent FIR which was registered against the petitioner, it may be treated as a 162 statement.
Oh, wow, how can I do that? It is a police discretion.
Lordship,
How can I treat one FIR to be the 161 statement in another FIR?
Lordship, because there is a judgment of the Honorable Supreme Court as well, the TT Anthony judgment.
What is wrong in this? You can go and give the statement.
Lordship, that is not that.
Party submits my letter. He has written several persons by taking money that he provided the plan. He has not able to give back to the.
Yes.
Thereafter, my lord, that person, since he has treated my lord, several persons have lodged there. So treated will not applicable in this case because he has treated so many persons.
So he, in one case, he has given 161 statement. He says that should be treated in all the cases.
No.
They put a FIR. So subsequent FIR, that will be treated as the 161 statement.
Oh, that way. No. That.
Lordship, because there's a judgment of the Honorable Supreme Court.
Which paragraph?
Lordship, paragraph number 19, which starts at page number 10.
10. Okay.
Page number 10 of the memo.
Yes.
Paragraph 19 at the bottom portion. Last two lines starts at page 10. Lordship, may I please?
Yes.
An information given under subsection 1 of section 154 of CRPC is commonly known as first information report, and though the term is not used in the court, it is a very important document. Now, Lordship, in the middle portion of page number 11, all other informations made orally or in writing after the commencement of the investigation into the cognizable offense disclosed from the facts mentioned in the first information report.
No, that particular case.
Lordship?
That particular case. If any other information comes, then those things will be treated.
Lordship, yes, and in this case, but Lordship, it is the same project, the Annexure 5 and Annexure 6 series, which I have attached to my petition. They all relate to the same project, that is Basera Angan at Patia, Bhubaneswar. And in fact, the learned RERA court's order at Annexure 4, that is also with relation to the same project, Your Lordship. In fact, the petitioner has also approached this Honorable Court for bail in different FIRs, and this Honorable Court has also been pleased to grant, and the Supreme Court was also granted.
You got the bail, it's all right.
Lordship,
sorry. But this judgment will not help you.
Lordship, there is in fact, because subsequent FIRs in relation to the same offense, same
I understood.
apartment,
You need
same
not repeat that, but this judgment will not help you. Do you have a judgment?
Then Lordship may grant me some time.
That's better idea. You just read it and come. Okay, get some direct judgment. This judgment will not help. Okay. Then counsel for the petitioner, after arguing for some time, seeks an adjournment to prepare the matter further and address the court. Lead to matter. You argued very well, but you have to get some good judgment.
I'll try to impress Your Lordship on the next date.
I'll just come. I'll just.
dispense, one of the IA has not been filed for dispense of the.
Why don't you do it?
My lord,
Monday.
in course of the day I am filing. My lord, बुधवार को आसू.
Tuesday. Both the matters Tuesday.
Yes, yes, ma'am.
Both the matter I'll dispose it up. Why unnecessary?
Yes, ma'am.
Tuesday. And give the particulars of that.
Yes.
Already.
Then noting is that my number is already noted in.
His name may also be reflected in
Yes,
this matter.
please. Now you know Tuesday. Even if your name is not there, you must come.
Yes, yes.
Yes. Yes.
I'm challenging a proceeding under the section Scheduled Caste, Scheduled Tribes Prevention of Atrocities Act, 1989. My submission is that a FIR as well as the statement do not disclose the offense under section 3, which says
What about the other offences?
other IPC offenses I am not.
Okay. Yes.
My lord,
What is the stage now? Cognizance has already been taken.
yes, my lord.
Where is that cognizance of?
Cognizance order I have not filed because at that time cognizance was not taken.
Then you argue at the stage of framing of charges, you move an application. I'll record that.
The case is posted to 4th April for starting evidence, my lord.
Charge has been framed.
Charge has been framed.
Where is the charge order?
Charge order I have not obtained.
That's it. You have to challenge that charge order.
Because the evidence is.
That's right. What is the stage now?
My lord, this is a.
You can't now.
This is a quarrel between the two.
No, whatever charge is 18 FIR. Now trial is going on. In between, you are filing an application for quashing up for the charge sheet.
No, my lord, but I have filed the FIR, my lord.
That's I understand it, but the trial has already started.
No,
charge has already been framed. That's what you are saying.
Charge has been framed, my lord.
Evidence has already been recorded.
No, evidence is likely to be taken on the
charge has been framed. You have to challenge that charge order.
Lordship may give me some time.
You do it. I'll give you that liberty. Right down. Petitioner is saying by invoking the jurisdiction of the court. Petitioner is seeking passing up for the FIR number barcode PS case number 274 of 2018 corresponding to GR case number 27 of 2018 registered against the petitioner for alleged commission of offences punishable under section 289 so. And then counsel for the petitioner submits that after investigation, charge sheet in the urgent case has already been filed, and subsequent thereto, cognizance of the offences has been taken. Even date charge when charge was framed, date even on such and such day, the court below has also framed the charges against the petitioner. Give the date charges against the petitioner. And counsel for the petitioner further submits that he is assailing he is agreed by the framing of charges
by the additional sessions judge.
Yes.
On 8th August 2023. No, it was posted to 25th September 23 for charge.
23 September 23. He submits that he is agreed by the framing of charges against him for alleged offences punishable under section 3 of SC/ST provision. I'm not inclined to entertain this petition at this advanced stage, particularly when the charges have been framed. However, the petitioner is at liberty to resort to the remedy, challenging the charge, challenging the order of framing charges in the appropriate proceeding, he'll so advise.
Lordship, may I say something, my lord? Lordship may say that I will move an application to discharge, taking all these.
A charge has already been framed. Where is the question of discharge? You have to challenge that only. You should have done it prior. I have given that liberty. You just see there. Yes. Yes. Dispose.
Lordship disposed it.
Yes, dispose it up with our liberty. Yes.
47.
Defense evidence is closed. I filed a petition that has been registered on the ground that there is no reason for collective order. Thereafter, I have filed a division, my lord, before the London
No,
Sessions
what-
Judge.
where is that order? First order?
First order, lordship, I will see the annexer 2, my lord, request 2.
16? Yes. 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 Order dated 8/7.
Page 16, my lord.
Yes. Order dated 8/7/22.
8/7.
Advocate for the complainant, advocate for the petition to recall. The order dated 3/6/2022 order.
Yes,
Where is
ma'am.
that? Where is
That
that?
is, I have filed a petition for 100, under section 370 petition, but I have not filed the urgent petition. That is why the evidence closed, my.
No, where is that order? 3/6/2022.
Your lordship, page 15, my lord.
Huh?
Prior to that, page 15, my lord. And except 2, my lord.
You can accept 2.
My lord. Page 15.
Okay. 3C. Advocate for complaint is present, accused is absent, but defendant is also to no separate petition for time that is evidence. And so, what do you want now? You want?
I want to like we adduce my evidence. Any date fixed, man, so that.
Yes. Let him do.
Yes.
Whatever, let him do. Because see,
No, he did not
defense
appear.
evidence. You want to lead defense evidence.
Yes. Yes.
You want to examine whom?
Depends on my the complainant, my. The opposite party. I am in the complaint case, man, I am the opposite party, my lord.
I know you want to cross-examine him. What you might have cross-examined.
No, evidence is not started by. Defense would have got it was closed.
Right. Petitioner is agreed by the order dated 8/7/2022, whereby his defense, his opportunity to lead defense evidence has been closed. Close. The close. The learned JMFC Bhubaneswar, while closing the defense evidence, has inter alia stated as under page 16. Page 16. You do the paragraph. On 3/6/2022, a petitioner had moved an application. The petitioner, being the accused in the complaint case, was absent, but moved an application over 317 CRPC, and represented through his counsel. But separate petition, but the counsel appearing for the petitioner had not moved separate application for adducing defense evidence. Therefore, the trial court has now closed the defense evidence, right to lead defense evidence. The petitioner is agreed by the same. Land counsel for the petitioner submits that a singular opportunity will suffice for leading the defense evidence. Regarding head to the statement made by the petitioner and the fact that the petitioner being advocated the indefensible right to lead his evidence in rebuttal, I'm inclined to allow the application by directing the trial court to afford the petitioner a singular opportunity for leading his defense evidence by fixing a particular date. It is made clear that no adjournment shall be granted to the petitioner on any pretext, and the petitioner shall conclude the recording of defense evidence on the same day. With this observation, the petition is disposed. Yes.
48.
Still confirming.
That order of Pranam is confirmed and this
One opportunity let him. Yes.
May it be lordship. The
Yes.
petition challenging the order of cognizance dated 28/10/2022 under 31 of domestic violence settlement on the 2 grounds, my lord. First, my lord, this petition is not responded in the DB complaint.
And we should notice the family dispute. Family dispute.
Notice
Acha,
what
you are
is
appealing.
the case, my lords? The
Acha.
present petitioner is the husband of the opposite party. Is the Deda Surab, I apologize. Is the elder brother of the husband. Now the JMFC Daspala had the present wife had filed an application under section 19 of the DB Act for residence and protection orders, which the husband and his family members violated. Thereafter, the wife had filed a complaint under section 31 for violation of that order. Now they have come in this present CRLC challenging that said order. And meanwhile,
What is happening in the marriage front?
Marriage front, Milots, they to my instructions, they had filed for divorce, which is pending, but they are not allowing the wife, despite the interim order for residence given by Learned JMFC Daspala. They have, may I finish? They have obtained a stay since May 2023. It is March 2025, Milots. They have succeeded in keeping the wife out of the house, despite she having a residence order to her favor.
Yes,
Milots.
yes, yes.
My mind
Is
comes
it
to my
in
lord. Plus, you kindly see, my lord. This petitioner was not responded in the DB complaint. First, my lord. My ground. Second ground is.
But
my
see,
petitioner is not accepted, my lord.
1 minute. See, the stay order is qua him only. His husband is not a party to this.
Milots, may kindly see the order dated 15 May 2020.
15 May
2023. Order number 1.
of this court? Yes.
Milots.
Yes. Yes. Further proceeding.
Entire proceedings in 1cc have been stayed. Now, despite the JMFC Daspala giving her residence orders, they have, when she went to stay, they threw her out of the house. They have
Not they, he. Because
Milots,
only
may
one
see
petition.
they have enclosed the complaint petition she has filed.
No,
At page-
he, see the book, even if it is state, this is state qua this petitioner, because the husband and everybody is there. He is the elder brother of the husband.
Milots, is their petition, may kindly see page number 16.
1/6.
1/6, Milots.
Yes.
4, 5, 6, 7.
Yes.
10 lines from the bottom, Milots. Situated in village Toila, Subarnapur. But when we entered, accused number 4, that is the present petitioner, with a threat, chase to assault, did not permit to enter, and the other accused person concealed with themselves, closing the entrance door from inside. This is the present petitioner, Suresh Kumar Gantia. And he has obtained a stay since May 2020.
What are the grounds?
Rational is 2 grounds, my lord. First, my lord, I am not the respondent in the DB complaint. Second ground is protection, breach of my lord. Listener is not attacked at section 31 of the bad man. Also, I can place, let's leave the.
He may not be a party, but she has made specific allegations.
Clear, my lord.
1 minute. Yes.
That's section 31, my lord.
31.
Penalty for
No.
breach of protection order by respondent.
Yes. 31.
A breach of protection order, my lord, or interim protection order.
Which one is 31?
Section 31, my lord.
Yes.
Here the violation of resident order, breach of resident order. My lord. Resident is not attached to section 31.
It's an interim protection order.
Interim protection.
A residence order falls under interim protection.
No, my lord. This is resident order.
Yes. Read it. 31 section.
Penalty for breach of protection order by the respondent. A breach of protection order or an interim protection order by the respondent shall be an offence under this act and shall be punished with the imprisonment either decision for term which may be extended to 1 year. My lord, what is respondent, my lord? Last week I listed the DB complaint case, my lord.
Yes.
Annexure 1, my lord. Annexure 1, my lord. Page 7, my running page 7, my lord. I am not the respondent, my lord. Respondent is my lord.
How will you address to it? Yes.
Lots.
It doesn't operate in RAM. You might have got the order, but it's you have not made him as a party in the DB proceeding.
Yes, ma'am.
How can you maintain a 31
Lots,
proceeding?
he may not be a party in the
But that's what there is a bar.
Lots.
Section 31, just see. Section 31.
Lots.
Qua him there is a bar, you see. The breach of protection order and an interim order by the respondent. By the respondent. Respondent in section 12 proceeding.
Lots, may see section 19 of the DB Act.
Yes.
The JMFC has ample powers to restrain either the respondent and all of his relatives in the.
But there should be, he should be a party to section 12 proceeding.
In the 19.
Section 12 proceeding which we initiated,
Lots.
you should have made him a party. He is not a party there.
Miss.
So the order passed. will not, you can't,
When the section 12 was filed, maybe there were no allegations against him, but when she.
You can't do that is why section 30, 31, that's what he says. Only it is binding on respondents in the original proceeding.
Look, I'll get back, Milot.
It is only binding on the respondents, those who are respondent in the original proceeding. That's what he says.
We'll call it next
Entry
week.
mode to continue. Yes. Prepare and come. 49. How will you get over 31? That's the very important.
This is listing it to next week. It can be disposed of on Monday.
Yes. You prepare and come.
And 31 is related with the protection order. This is a resident order, breach of resident order.
You read it, you not read it. Read the law now and get some judgment also. Okay?
I'll get it.
49. May I please let's see, madam.
Yes.
My lord, sole ground of challenge, my lord. This is a method of criminal nature given the civil nature, given the color of criminality, my lord.
Yes.
The noting is that the objection has been filed by the opposite party, my lord. But I have not received that.
Yes. Have you filed any objection?
Yes, the noting is there, my lord. I am.
Objection, yes.
Yes, my lord, I have filed the objections. My lord,
You must give a copy of objection to the other side.
during the
You have a copy. Acha. So attended appearance on behalf of opposite party and
my lord, I will do it.
objection to the petition. The copy of the same has not been supplied to the counsel for the petitioner. Then counsel appearing for opposite party is that during the course of the day he would be supplying the copy of the objection. Lease the matter on so and so date entry order. Entry order is there.
That may be disposed of.
Okay, lease the matter. Good to week for a photo matter. Yes. Yes.
50.
Yes.
Should kindly keep this matter next week. Next week. Kindly keep this matter next week.
Notice on the opposite party number 2 list official who were non-agented appearance. Learn counsel for the petitioner seeks an adjournment. In the interest of justice, release the matter on Sunday in order to continue. Yes.
51.
One matter. For filing counter, one. For filing counter.
So and so entered appearance for opposite party seeks 1 week time for filing counter affidavit. Counter affidavit. Let him do so within a week. Lease the matter on so and so the entry order to continue. Yes.
52.
Yes, sir.
Lordship, this matter.
Mediation report. What
Mediation. Mediation report comes.
Successful.
Mediation
That
failed,
is
my
failed.
lord. Let him complete, my lord. Let him complete.
Mediation failed. The husband ready to take their wife, but the wife in a day. Can see the report nice.
Anyway, she's not ready. Not ready. Nobody can force.
One cannot force to
Nobody can
his
force.
wife to.
Now come to the point now. Come to the point.
Order taking cognizance under the let him complete.
Lordship, if the
Prime basic
did not ready,
307 is
lordship-
prime basic 307 is case is make out. But the husband and in-laws are putting on our bag. Kindly have a glance to the FIR. Page 30. ଅଧ୍ୟକ୍ଷ ମୋ ଗୋଡକୁ ଚଉଡି କିମ୍ବା ଗାମୁଛାରେ ବାନ୍ଧି ଯାଉଥିଲେ
You are challenging the cognizance order. Huh?
challenging
Yes.
How 10 lakhs they are demanding. They are taken car.
What to do?
Lordship, if
They have not
did not
appeared.
ready
Till
to
today,
go
they
back,
have
my
not.
lord.
They have not appeared.
Any amount they
No, my lord.
may be settled.
No, my lord.
If she doesn't agree with something, I can't force her. Nobody can force.
Lordship.
And in so far as cognizance order is concerned, it can't be quashed because there are specific, very serious allegations. So because it's a matrimonial dispute, I have sent it for mediation. You should have persuaded your wife what to do. The wife doesn't agree. In all matrimonial dispute, the end is settlement. Obviously. But
Till today they have not appeared.
If
Summons were issued by the Honorable
is they
STM.
ready for settlement?
No, my lord.
She's
No
not ready
question.
what to do.
Lordship.
Can anybody force?
No, my lord, contest.
And you raise all these points before trial court by
Your
moving application.
Your lordship.
The matter was referred to mediation by the order dated order dated 14/3/2024. The parties have participated in the mediation process. However, no result yielded from the mediation process. The mediator has given a report dated 8/4/2024, which is placed on record. The opposite party number 2, represented by Mr. Hon'Ble and counsel for the petitioner, submits that she is not ready and willing to settle the dispute. So in view of the nature of allegation made by her against the petitions. Okay. I have in the present petitions are seeking quashing of the cognizance order dated 31/5/2022, passed by level by CGM Bhubaneswar in city case number 5620 of 2021, whereby the cognizance of offenses punishable under section so has been taken. Regard being head to the nature of allegation and the evidence placed on record, I am not inclined to entertain this petition. Hence, the same is dismissed. However, liberty is granted to the petitioner to raise all the points before the court below at the appropriate stage by moving the appropriate application. If such application is moved, this will be considered on its merit on the basis of the material available on record. Yes.
Madam, target.
In his petition, you want
in the window also the London court also pass maintenance of that is 15,000.
It's better that you should settle.
Your lords.
You pay.
It's a different proceeding. 125%. I know that.
Admittable was recall me.
Yes.
Your lords.
Complaint.
Yes.
Last time I was directed me to file certain document related to the fact that I have the present petitioner, by virtue of participating in the process of auction, he has been allowed to lift some PSC, that is placed concrete sleeper, is meant for the lying of the railway track, and after a particular period it will be damaged, and by the procedure.
What are you challenging?
But the order of cognizance.
Okay.
And as for the procedure, after a particular period, it will be damaged and it will be auctioned, and the person concerned will be taken away. And the sleeper, which is made of concrete, will be broken to pieces. Some iron and some wire will be left out for that particular things, and it will be taken by the concerned bidder. That is the usual process. By the process, arbitrarily by process of auction, the parent petitioner has been allowed to take around 12,468 pieces of sleepers, and he has taken a part of it and left because it requires some sort of labor work. And by the nose, it always lies in a.
You are appearing.
I am appearing. Yes. For the union, and it always by lie in a particular place which is far away from the real road. It requires to be lifted up from the particular place to a particular place, and that will be broken. And by the process, some manual labor and some time is needed. So at the relevant time, but because of that, the present petitioner has taken part, and this some other a part of the auction piece, and some other parts were lying over there, my lord.
Yes.
Subsequently, when he tried to lift up, my lord, by engaging laborers were there for about a month. It was broken to pieces, and the collection, the wire and the iron rods were collected from the particular place at the relevant time. Allegation has been made by the authorities that the things was not sold to the petitioner, and in excess to his given allotment, he is taking, my lord. So that's why now the case is there. So my humble submission is relevant because this particular piece is always kept in a number, and they made a diary out of it. 5,000 pieces dropped here, 6,000 pieces dropped here. So like this. So they have to establish that in fact, which is the materials, which is the dump I have committed.
They will establish.
Pardon?
They will establish.
Yes, they have got the establishment. That is
they will establish. Wait.
No.
In the right says they will establish.
It's not the case that I have taken away from it. Admittedly, the particular.
How can I venture into all this thing at the stage of cognizance?
No, my humble submission, when they have submitted the PR, it is also they are bound on duty to say which materials I have
The
taken.
allegations, just see page 11 and all.
Yes.
The allegations are very clear and it's
have
a very
admitted-
detailed PR.
No,
It's
my
not
my humble
personally
submission, they have admitted that I was a successful bidder and I have entitled to lift by a certain 12,460 pieces of PSC from the particular place.
You exceeded that.
Pardon?
You have exceeded.
No. That is their case. It is my case that as I have said, it requires to be broken to pieces for months together. It's required because it has to manual persons have to go, the labor has to go and make it broken. Thereafter, they have to collect it. They have dumped it, and by the process, after about a month of operation, I am somehow able to get it the residue, and which I was when I was about to take it,
It's very detailed PR.
Yes, they have not. They have not said anything that which dump I have taken, my lord.
Yes, what do you say?
Yes, let them say.
My humble submission is, my lord, no SRO was pending for transportation. SRO is sale release order.
Yes.
On the basis of sale release order, they transport the material. By then, after the auction is conducted, all SROs were exhausted. No SRO was pending. That is the specific case. If your lordship will turn to the PR at page 12. Yes, Lord, page 12. Internal page 3.
Yes.
Running page 12. Towards the bottom, your lordship can turn to.
Yes.
Enquiry. Starts with enquiry.
Yes.
Enquiry has been conducted from Sharat Chandra Bardjana, senior section engineer, QA Bhadrak, and he stated that those materials were being delivered to the purchaser, Kamadhenu Traders, Raipur, but on demand he could not produce any document. Even he has no any pending SRO and not informed to RPF or accounts, and process of auction delivery was not followed. On further asking, he stated that Kamadhenu Traders, Raipur had purchased 12,460 pieces of PSC slippers, but he had left about 2,000 slippers after delivery.
Yes.
However, when verified the documents, it was found that the total materials of the said SRO, total 12,460 pieces, and all materials had already been delivered to the farm bidder Kamadhenu Trader, Raipur. Details as on 13/7/2021, 3,986 pieces. On 14/7/2021, 3,395 pieces. On 5/8/2021, 4,536 pieces.
Yes.
And on 6/8/2021, 456 pieces. So the statement of Sharat Chandra Bardjana, senior section engineer, was found false. After getting information, the PK Sahu, Inspector RPA Bhadrak, along with officers and staff of RPA Post Bhadrak, also attended the above spot and confirmed that senior section engineer Bhadrak had not informed to RPA Post Bhadrak about any auction sale delivery. It was his bond duty to inform the authority about the
auction sale was made authority.
All these can't be segregated.
No.
These are all
The officer who has investigated, he doesn't have the knowledge that it was auctioned by the authorities. But admittedly,
how can I go into all these things?
No, I have a simple point, my lord. I pray, my lord, but to have my friend may answer, my lord. Admittedly, the things were dumped in a particular place. Suppose
the only thing is you had a valid tender.
Yes.
You succeeded the tender.
Yes, my lord.
But after the tender work is over, still you continued.
No.
And taken.
No, my lord, that's why my humble submission. Yes.
Taking advantage.
I have by virtue of a valid tender, I am entitled to lift 1,200.
You've done it.
No, my lord.
After you kept on continuing it.
No, my lord. My humble submission.
Yes.
Because of the fact that these things, where a considerable amount is there, 5,000 to 2,000 like this, they're dumped in a particular place. So now they have to at least say that which one I have taken. Because kindly appreciate, it's not that one, my lord, the things are only
the onus on them to prove it.
Yes.
They will prove it, otherwise you will be acquitted. But how can I go into all these things at this stage when the cognizance is
my lord. My
cognizance
submission,
is rightly
when
taken.
they are filing a PR against me, at least they have to establish that which item or which.
Can I appreciate the PR at this stage and pass an order or discharging you?
Now, my lord, they have to say, because admittedly I am the person who has to lift up the 12,000.
I don't think you have.
They have to show at least that on which date I have taken, my lord. At least they let them say so. Let them say so with the affidavit on such and such that I have taken, because it has to be rooted with, because my lord, the thing says to be, because it was inside the railway on a particular day, if a particular person has to lift up,
Put those put the question to the witnesses.
No.
They put-
Witnesses, my lord,
Then we
be per moment. On a particular day, suppose I have to lift up, then I have to lift up through the permission of the authorities. Let them say on which date I have lift up.
That's the date they have said.
No.
When 3 persons were apprehended there in the spot and they were confronted, they could not produce anything. Therefore, this case is filed.
No. The persons who have been apprehended.
All the 3 persons are your persons.
No, the persons who have been charge sheeted, they are not the persons who have been apprehended in the spot, my lord. But bear me for a moment.
And whose vehicles are there?
Yes.
These vehicles,
Other persons?
no,
Other
vehicles.
persons? Not of the
Where from I'll get it? Then I have to venture into the entire merits of the case.
I'm sure that I'm confirmed that while considering this case of cognizance, I will not get into all.
You are sure that today I'm not with you. You want an adjournment, I'll give you.
Yes, my lord, yes.
I'm not with you.
Yes, well, that will be better.
No, that is better. Simply adjournment. See, I can't go into all these things.
No, because they have to establish that which item or
they will be establishing. Therefore, you have to face the trial. They'll establish it. If they don't establish, you will be acquitted. Then it's a good case for acquittal. Face it. I'll target it.
My lord will say after some time.
Okay.
My name of Mr. Partha Sarath Naik may be deleted. I have appeared in this. Vibhuti Bhushan Mishra, my age.
In place of Partha Sarath. Yes.
55. Lordship adjourning it to
after 2. Yes.
55. Lordship, here it's an application for quashing of cognizance for
And notice was issued.
Notice
Yes.
was issued.
Who is appearing?
The informant is also appearing.
Appearing.
But
Yes.
Here.
Matrimonial dispute. What do you say?
It's not even a
498 and
matrimonial dispute, my lord. She claims to be my wife. After 10 years, my lord, marriage is alleged to have taken place in 2013. She sleeps for 10 years. 2023, she lodges an FIR that under 498A, the SC/ST Act, my lords. SC/ST Act also doesn't apply to him, my lords. My lords, it appears that the wife, the mother of the petitioner was abusing this particular lady. So that is 10 years back. And she relies, for a marriage, she relies on this annexure 3, a deed of marriage, which is sworn before a notary, my lords. Time and again, this court has also said, my lord, that this deed of marriage is just nothing, my lord. And on top of that, 10 years she sleeps.
My lord, admitting that the deed of marriage is voidable. When the deed of marriage is void, is not applicable. But the present petitioner has abused his wife outside the
10 years back. 10 years back.
No, my lord. It's 16/3/2023. My lord, kindly turn to
You first
page
of all,
41.
you first of all tell me how you have when you married. What is the proof of your marriage?
Marriage, my lord, has happened between the Godachandi temple on 18/2/2013. After that, the petitioner refused to stay the informant, and consequently,
You are already married. Otherwise,
Yes, the boy has already married. She knows that if a criminal case is filed against him, my lords, he will be. It's just an attempt to blackmail this person.
No, my lord, that's absolutely not correct. Before marriage, the present petitioner has law affair with the informant in the year 2019. In the year 2012, the present petitioner refused to marry the informant. Hence, the informant has appeared before HRPC in 2012. And after the settlement, 18/2/2013, the present petitioner and informant married.
you just come to page 31 in that notary thing where the marriage is solemnized according to him.
Yes, sir.
Is it your signature?
My lord, he denies that it's his signature. My friend told me that it's not his signature.
Because see, this marriage is not void marriage. Before notary public, you have done it.
No.
But the fact remains that you yourself have gone with this girl and both of you are party to this.
He says that it's not.
Today you can't rely upon a document saying that this marriage is void and all. And thereafter it appears to be you have stayed with him. Her.
No, never.
Never. My lord,
that's the allegation.
My lord, just.
My lords, there are a lot of allegations being made against a lot of people, my lords. my lord, the allegations prima facie have.
Why don't you, do you,
After 10 years. my
are
lord.
you going to settle? See, ultimately, he is already married. You will get some money, that's all.
No, no, no.
Beyond that,
No, my lord.
will you marry him? He is already married with someone.
My lord.
10 years back.
Kindly come to page 11.
Yes.
The informant has obtained signature of petitioner on a blank paper. The present petitioner has admitted on its claim.
It's all right, but what will you get at the end of the day?
But
you can't marry with him.
My lord, my point is that the petitioner has abused the informant
I
outside
understand,
the police
everything is
station.
understand. At the end of the day, what are you going to get?
If
you are claiming him to be the husband, okay?
Yes.
And the fact remains that he has already married somewhere.
Yes.
You can't marry him. It has to be settled. It is basically a kind of matrimonial dispute only.
Yes, my kindly come to mediation.
He is working, at least he is capable of paying you some money and settling your life. Why are you pressing this? At the end of the day, nothing is there. You are not going to get anything. He may lose the job. He may lose the job. You are going to get nothing.
If the present petitioner cohabit the informant, then what will we do?
I understand the plight, but what are you going to get out of it? Shall I send it to mediation and try to find out the way? And you also pay something. See, otherwise, see, at the end of the day, both of you are the losers. Pay something and finish it up.
In absence of a
Have you married anyone?
statement.
Have you in between married anyone, or you are not?
Yes.
You are also married.
Yes.
Then
leave him. Married is that the atrocity act. My lord,
leave him.
married
You
is
need,
the atrocity act.
then obviously you need some money.
No, my lord.
Obviously you need some. You are married. He is married. Why are you after him?
No, dispute is.
I am sending you mediation. Negotiate and pay something and finish.
And she go, my lord, I'll talk with her certainly, my lords, but mediation because she is. My lord,
Today you deny or don't deny. You are in relationship.
the
with him.
president of the
And
US was
you
also in a lot
have
of
you have
that doesn't.
now you have to pay
make
something.
the relationship legal, my lord.
Pay something because you are in relationship.
I'll
Relationship it gone wrong. It seems it gone wrong.
My lord,
Both of you could not
if it can be settled by
gone
some-
wrong. So therefore you pay something. He is also settled. She is also settled. You are also settled. You are working. You can pay.
My lord,
Regarding
mediation.
Regarding head to the nature of allegation made by the opposite party against the petitioner, I am of the principal view that the parties can explore the possibility of settlement. Hence, the parties are relegated to High Court mediation sector for mediation. The coordinators are speaking with. Since you are working, I'll allow you to participate in the video conferencing if required. The parties are at liberty to request the mediator for appearing through video conferencing if necessary, and awaiting mediation report. These matters also interim ought to continue. Try if you can work out. Why
Yes,
not?
fellas.
Yes.
6.
Last yesterday, my lord, I have given a case on me. I didn't take it.
Yes.
Madam, I may pardon my lord. Yes, under section 130 NI Act. My lord, the main issue, this fairly covered, my lords, this year. The main issue, the Lord and Magistrate has taken cognizance without taking 200 to inquiry. Only affidavit, only IFR vacation of state. I pray.
1 minute. So I'll put it next week. Yeah.
Next week, except 19 any day.
So
No, 19, yeah, 18 also. 19 rahibe. 20.
1 minute. 1 week time to file response to the petition. Least the matter of 24, 25. 24.
7.
Yes. Yes, sir. Permanent elimination.
My lord, I am DK Sir appearing on behalf of the petitioner. During the last occasion, your lordship has directed to issue notice to OP.
Actually, I didn't know the matter was listed today. That's why
So entered appearance of opposite party number 2 and seeks an adjournment for filing the response to the petition. let him do so within a week. Please the matter consent the interim order to continue. Yes.
My lord, interim order
Yes.
to continue.
Continue. It will continue.
59. I took 58.
58.
May I please? At the outset,
BJP 58.
But at the outset, if I can update your lordships.
Oh, this matter.
Lord, I'm sorry I was not able to make it this time.
Yes, Mr.
59, your lordships are directed, file the status report.
But they should have given it to us in advance. They're doing it today, Lord. Copy to you.
And that cannot be supplied. So this is a part of investigation.
Sorry, ठीक है এটা কোর্ট পেপার আছে
It is I'll have to go through the entire thing.
Yes, yes.
I'll have to go through the entire thing. Because a substantial development has taken place. It
Yes, sir.
appears to be.
May I
Yes.
indicate?
Yes.
I'm so sorry. If I may be allowed to update your lordships as to what the difficulty in this matter is, because something that was indicated by your lordships as being of this much is being made by the investigating agency into something which is outside the entire process of what is being considered. When your lordships look at the last order, the lordship said there are certain documents that we have filed. The entire issue was documentary in nature. We had indicated that they were calling us from outside.
Have they called you?
Lords, let me put it this way. I am amazed at the fact that not only have they are entitled, they are investigating agency, they can call anybody, they have called us. In fact, some of us have come, we came, the questionnaire is being prepared by the complainant, the answers are being given by us, all of that is going on. We are staying here for multiple days, no difficulty. We'll suffer that. Lawyers are being called. Lawyers in law firms are being called as witnesses in this investigation, as if there is some kind of a larger issue here. What your lordships have to look at is, we came here at the stage of an FIR to test broadly at the very outset what is the nature of allegations made and whether there is any basis for that. Because if there is some basis, your lordships will not interfere with the investigation. Your lordships will allow the investigation to continue. And hence your lordship said, look at the documents that are being supplied by us on the last date of hearing, analyze those documents and file a status report. To us, nothing has been supplied. Something has been handed over today to your lordship.
What the lawyers summoned?
The lawyers who had asked for the signatures, the AZB and Company, Barucha and Partners, two eminent law firms situated in multiple cities, but particularly in Mumbai in this case, their partners are being called to answer questions about what had happened in the transaction, as if the complainant does not know. Or everything that we have provided is emails where the complainant is marked. The complainant does not know. The lawyers are being called from out of station. Ladies are being called. Ladies are being called. And that is the investigation going on.
Yes. What is
the problem, Lord, is
how can you call the lawyer are acting on the basis of instruction of someone? Why are you so over enthusiastic about it? Why are you calling the lawyers? Then tomorrow the lawyers, those who are appearing, you will keep calling everybody. Who has given you the authority to call the lawyers? Lawyers act on the basis of the instruction of the clients. If the lawyer, somebody is drafting a petition, a document, And you have called the complaint or the person who is given instruction. How can you call the lawyers? I'll not tolerate this thing. If I file an affidavit.
I'll straight away, brother.
File an affidavit. I'll take you to task. I'll tell you. Don't even call any lawyer for investigation. Why are you so over enthusiastic? I'll change the investigating officer then. What is this going on?
Your lordships have said all are on basis of documents.
Let him do whatever, but no lawyer should be summoned for investigation.
For being.
They are complaining.
Why are you so over enthusiastic about it? Who has given you authority to call the lawyers for investigation? Then the lawyer will be there in the police station then.
He has not called him lawyer.
Yes, there, yes, I have. Ms. Karishma Dugar, AZB Partners, has been called by a notice of 27th of January.
What is this going on, Mr. Then all the lawyers will be there in the police station.
Personally present.
He is not lawyer.
No, law firm partner. Law firm partners. Then what will happen, you know? Then all of the lawyers will be in the police station tomorrow.
Case or the other, they'll call us.
Yes, what is this going on? You can call the complainant, you do whatever. But lawyers are not, lawyers are appearing or drafting whatever on the instruction.
Now your lordships.
And change the IO. Change the IO.
I have one request.
Even one lawyer is summoned for investigation. He has to be. No, you change the first change the lawyer, investigating officer, and inform me.
I have one request, and
we don't tolerate this thing.
I am entirely willing to the lordship's hands.
Let him. I'll read it, and make sure that no lawyer.
No lawyer will call.
Come what may. No lawyer should be summoned for the purpose of investigation. The lawyer does on the basis of instruction.
Tomorrow, anybody in this court can be called.
Yeah, anybody. Then tomorrow, the lawyer, those who are appearing, will be summoned by the.
I am actually waiting.
How dare a lawyer will be called to the police station?
I have one request to your lordships. My request to your lordships is this: your lordships may go through that whatever has been handed over. If there is some.
All documents are there.
That's what. See, the problem is I can't advise the investigating officer how to go about it. I'm very sorry that a lawyer, whoever may be, a junior lawyer also, it is an harassment to a lawyer. A lawyer on the instruction they work.
And we have challenged the FIR.
Vicarious liability of a lawyer.
Absolutely.
I have one request, I beseech this court. Please consider whatever they have filed. Let me no difficulty at all. My submission is this. Today, Milords, I came at a stage where I believed, and I may be wrong. I'm willing to be judged on that position.
See, the problem is I can't scuttle the investigation at this stage.
The position is this. What your lordships will do, Milords, is this. Your lordships will strike that balance. Your lordships will say, I will not go purely on the basis of what the accused is coming here and saying to me. No difficulty. That is why your lordships on the last 3 dates of hearing said, Mr. Investigating Officer, you have some material that the accused is giving you. You have some basis. Verify this. Give me a preliminary assessment of whether.
I think he has done it and given.
First of all, not to us.
Unfortunately, it can't be given to you. In the intermediate stage. Let me go through.
No, I have no difficulty. My only request, Milords, is this: that even today, what is being asked from us is every single communication, give us the entire set of emails, come for days on end here physically, there are 100 questions.
See, perhaps I don't have a jurisdiction at this stage to control everything here.
Which is,
but I'm sorry, but if the lawyers are called, this is not acceptable.
Which is, I'm saying that your lordships may set down the matter for hearing next week.
Yes,
and we'll finally hear it.
Yes. Please do that. I'll hear it. No problem. Let him come.
Yes. Next week would
sometime week after. Yes, week after I'll do it. Let me go through. Let me go through.
The lordship will go through it and fix a date.
But make sure that. See, lawyers are not.
No, my lord, we are all in agreement.
You don't respect the lawyer, then end of the day.
My lord, just one till then.
And generally, what happens, I'll tell you. What happens generally in the law forms, if you ask some lawyer partner to send, they'll send the juniors. Just naturally, the partner will not go. The junior lawyer who is drafted they'll go tell that to go and face the, and what kind of harassment a junior lawyer faces, just imagine.
Milord,
And he will be made to sit outside. And what is this?
No, more than that, in any investigation, anybody, all of us can.
Anybody can be called then. The lawyers are not.
We all are in agreement about that, my lord.
Yes.
We are
And
all
change the IO.
Milord, I have a
Let them put it on
May
affidavit as to why they called it.
I have a small submission.
Can't be that they can't do it.
My client was called on 4th and 5th. He was called. He came all the way from Bangalore. He was there from morning till evening. They prepared 100 questions. They couldn't complete it. Asked me to stay over for the next day. Next day, I cancelled my flight and stayed over. They 1 hour they examined 45 questions. Thereafter told that you can go and some other day I will come. How many times will I come?
Perhaps those things I can't enter in.
These are all the basis of documents. I have submitted all the documents. What?
We'll take care of that also. We'll take care of
Let our clients be examined on BC. All documents have been given.
See, the problem is I can't control the investigation process.
Fix it for hearing.
Here. That's the
Next week,
yes, Mr. Luthra.
We will ask the lordship to test the FIR on the next date. But all I'm saying is not, my lord may keep it on a date, hear the matter, determine it either which way. Meanwhile, your lordship has the benefit of the court and an affidavit as to why lawyers are being called like this. But that should come to the
Substantial development has taken place. It appears to be that the investigating officer has given.
There may be weight in that, whether there is substance, that is for your lordship to determine. Weight, it's
no, substantial development I say because of it's a number of pages, you know. I don't know what there is inside. Many a time what happens is complaint is reproduced.
Which is exactly what would have happened.
Your lordship
In 2-3 pages, it's a reproduction of the complaint. But what has really come out, let us see.
Because in some jurisdictions, lawyers are given and maybe officers also by the para. So therefore, maybe it seems to be like that.
I'll fix a date.
Only minutes after holy.
I'm sorry. Please have it next week. No. Please have it next week. I am today. I am here. I am here. Your lordship has the document. Let me begin.
No, I have already protected you people.
I conclude my arguments. Look, 20 minutes, I will conclude my arguments. I have nothing more to argue. There are 4 documents to be seen.
Where do you want?
Case.
When can I
go through that? But the entire purpose is to
see what I'll do is subject to the consent of all. Let me read it.
Yes.
Then and accordingly I'll fix it.
Yes.
Authorize during the holy also will be called. Because now I have to miss the holy. The only we would not have.
Who knows that during holy your clients will be there with you, attending investigation. They will play with you.
Understood.
Suggest that this complaint should come. It sends a very bad message, you know, if you keep calling lawyers.
Same time, I tell and this
Sorry? Sorry?
At this stage, when the matter is already, bio is already about to complete substantially investigate the matter.
I'm not directing because by showing the way he is over enthusiastic about it, why he is investigating, no problem. Let him do. That is his jurisdiction. Nobody can interfere. Now even court can't interfere. It's all right. But why so many? See, they are seasoned lawyers. They can't complain like this. For heck of it, they will know. They will not do it. They're doing it means somewhere it is pinching. Why this complaint?
But I think
why this is happening? See, these people, they are not irresponsible people. They make an allegation against someone.
In Bombay, it is called Asuli. In Andhra, it is settlement. In Odisha, I don't know what.
This acts as,
What is called resolution, resolution.
In fact, Vasudha directed the last time to take step for settlement. But nothing.
No,
No, I'm sorry.
I don't think that's settlement.
My lord,
They don't agree for it.
This is, and that's exactly, I think, what my learned senior has said. My learned senior said on the Vasudha and the settlement. That is exactly what the position is. The purpose of these proceedings is only that, and that is why it needs to be nipped in the bud. My request for your lordship is because we are also coming from out of station, and whatever date your lordships fixes, if we are not here to assist your lordships, it would be our loss. May I request one thing? If your lordships indicates any date at 2 p.m, if your lordships takes it up if convenient, and we'll be here. This matter actually does not require so much.
Yes.
I know, but I want that the due process of law should take.
No, I bow down, right?
Not that I can't scuttle in between.
At the same time, my lord,
There is a complaint. I tried for settlement. You didn't agree for that. It's all right, but due process has to take care of.
We are not on the investigation at all at this stage. We are saying that in the inception, whether the FIR can survive or not survive. That's the matter.
That's right. We'll consider it. No problem. I'll give a date by consulting you. Consulting you, then.
my lord says another fresh CRLMC listed today, 586 of 2025. My lord says.
My lord,
Notice can
we are
be.
entitled to say it's an abuse of process, lord.
And my lord, it's the same
Yes,
in
notice.
orders.
Notice. Yes.
We have two
So that they
IAs.
get the benefit of the interim order. Yeah. Yes. Thank you.
Now, quorum at the item 6, only one admission matter. Tuesday.
Like today, if you want to do, you can do it. 60.
Yes.
You are not there after lunch.
Okay.
You are not there after lunch.
No, after lunch.
Okay.
18th.
Because
Thank you.
we'll seek the date.
Huh? 1862. Yes.
Item 1.
Yes.
Item number 1, I filed the after getting MSc and PhD council.
Acha.
My name is not reflected. Your
Yes.
lordship and
Mr. Tirthukmar Sahu has entered appearance for opposite for petitioner, taking no objection from Satyanarayan Mishra. Let his name reflect in the cause list and release the matter for hearing. Vocal no taken up.
Item 6.
In this case, if there was registered on the date of the other vice, then final form is filed, PDC got their dates. Even the trial is not.
I've changed.
Trial charge has been framed.
On
Trial is not started.
What charge has been framed?
charge it from
FIR is 2023.
30/10/23 charge sheet has been submitted. I'll take it.
Charge sheet filed on.
PDC got their dates.
What are you asking?
My prayer before this annual from that complete the
What are the offences?
429.
420.
67 lakhs, 67 lakhs.
Huh?
67 lakhs, 420 case. I'll take Mr.
I will pass an order and dispose it up to as expeditiously possible. That a petitioner is agreed by the non disposal of the trial proceeding. Despite the fact that the FIR was registered on 23/9/2021 and charge sheet has been filed on 30th October 2023. Land Council for the petitioner submits that the trial has not proceeded in the inch even after lapse of more than 2 years. More than 2 years. Hence, he seeks indulgence of this court at this stage. Do you have anything to show that proceeding has not started? Apart from that, the petitioner has also urged various other points. I am not inclined to entertain this petition at this stage. However, it is expected that, however, needless to say that the petitioner being an accused has indefeasible right of is a right, constitutional statutory right of free, fair and speedy trial. Hence, it is expected that the trial court should do well to see that the trial is expedited and concluded as expeditiously as possible. With this observation, the petition is disposed of. Yes.
Item 12. Petitioner has been charged under section 376 and section 482. So there has been a compromise between the petitioner and the victim.
You are absconding. You are absconding.
Yes, before 2 CRLMC petitions prior to this, my lord. The CRLMC number 560 of 2615 of the 2010 and 566 of 2018, my lord.
What happened?
And in the first case, it is stated in the, my lord, the net that has been dismissed. And another, my lord, that was dismissed for non-prosecution. There is not. But what
You
is
have,
challenged is
you have
that-
approached twice. Where are those orders? Huh? Where is that order? What happened to those 2 cases which you have filed? And what for you have filed?
What is the prayer in that case?
Passing on. Then repeatedly you are approaching and it is
And
being
the
dismissed.
abscond-
Maybe you must know why for it was, what was the prayer there? Same prayer and same ground. And then how can I, one court you argued and it dismissed. Now how can I?
Then CRLM.
You disclose all this thing and place all this thing in writing. Where is that order? You show me the order. You can't
Withdraw kori better order, better file karo. Sabu de di particular.
You approach this court twice. Where are those orders you tell me? Where have you shared those things? Yeah. Yeah, on merit it is dismissed. So what to do? Now there is a Supreme Court judgment against you. That's right, but have you prepared? You people don't prepare and you expect me to prepare. There is a judgment of Supreme Court. Have you read that judgment? In a POXO case, you can't be quashed. Have you read it? You read it and come. Read it to come. Yes. Urgent. Yes. Read it and distinguish do something, some research work. Yes.
13 years at the time of preference.
Shall I write it falsely implicated and allow? You distinguish one petition has been already dismissed by a speaking order, relying upon Gyan Singh. He says that Gyan Singh is not applicable in your case. Yes. You have to read, you have to get over all these judgments. Yes. Read, prepare and come properly with all judgments. Yes. You file it. Yes.
28.
Simply urgent, find out what exactly happened. There is no clue because it is referred to some CDO.
We did file that application with the affidavit.
The order is not there. And this letter is from Educational Tribunal, referring to disposal of GIA case in FAO 522. This FAO is 655. No, the FAO number is 655. 655. The letter is 655. Let's see. No, 522A FAO 522 2020. And this is wrongly listed. This is wrongly listed. Yes, verify. Wrongly listed. TPS2. Yes. Yes.
61.
Give it. 61. Yes. Yes. 62.
63.
May it please, my lord, I'm appearing virtually, my lords. I'm the petitioner in the first matter, my lords.
On behalf of Mr. Manoj Pati, kindly go for an advertisement. It's an official statement and he's trying to trying to accept the workshop, but due to some technical reasons, he's unable to.
For opposite party?
Opposite party number 359 is for opposite party number 2B.
Which item? So it.
Yes, so I did. Yes.
Just favor of this faculty. Let him take time, but there's some urgency. There was a project undertaken by some builders, which went into the OPID Act because the builder used persons. Now the authorized officer ascertained the claims of the due person and said the sale proceeds out of the assets which is confiscated. Out of the sale proceeds, they will be given, the dues will be realized. Now, here before your lordship, as a landowner, in 397 sub-item 3, as a landowner, my claim has also been adjudicated. And the authorized officer under the OPID Act has found that I am entitled to 33% of the land, 32% land.
Yes.
So what my grievance before your lordship is, he should have released that portion without saying that it should go for auction. So that is why I have approached your lordship in this appeal. Now, I will suggest, my lord, subject to the consent of others also.
Yes.
My client and the client of Mr. Devashish Panda, who is in the sub-item 1, stands on almost similar footing because his land also, the client of Mr. Devashish Panda's client.
Ultimately, you are interested in money.
No, I am interested in the land itself, land and the project. I'll pay off the entire, whatever the valuation is, if it is decided by the.
There is a collaboration.
No, it is not in collaboration, my lord. client of Mr. Devashish Pandya's project is at different place. Mine is different, but we stand on the similar protection.
No, you are not the builder. The developer is someone else.
Investor, in the
Okay.
sense that I have given my land and it was found that he has cheated. So I am ready to sell off take that land with whatever price the valuer decides and pay off the dues of the investors. So I am entitled to 32%, so 68% I will back.
But the investors might have made you as a co-accused.
No,
No,
I am not a co-accused. I
only the
stand
developer.
Similar footing to the investors. That has my claim has also been adjudicated by the adjudicator, saying that I am entitled to 32%.
Yes, Mr. Panda's client also agrees to that. Yes, madam.
My lords, we'll
This
have to seek
proposition, what?
My lords, we'll have to seek instructions with that regard, my lords. But we are also in a similar footing to what my learned senior is placing. We are also one of the landowners, and we are also interested in the land, my lords. But the proposition which Mr. Dutt is
You
proposing.
people are appearing for the developer.
Yes.
They are the developers. They are the main contesting party. Okay. Then I'll put it one week after his request.
In other ways,
Hmm.
I would also challenge if that can be put into auction within a stipulated time. I'll participate in the auction.
Whatever, it should be put to an end so that you can get back your money and today or tomorrow it has to be done this way or that way. It can't. They can't be get stuck. They are not co-accused. They have advanced their land. On that land, the builder is supposed to develop this thing, and he has collected money showing your land.
Yes.
So it has to be.
And Mr. Devashish Pandya's client also has a separate piece of land. We do not.
How much you had taken from builder?
No, I have given the land to the builder. I am not taking. We had a development agreement with the builder, but the builder found eventually was a cheat. Found to be a cheat.
No, but see, if you are a you had a development agreement.
Yes, ma'am.
That's in the nature of collaboration. Then you some flat must be given to you.
32% was my claim. It was that the ground floor and the first floor.
Have you sold your portion of entitlement share?
Yes.
You also sold to the people.
Yes,
They must be
not
claimed.
to the people. Not to these people. I was due because my land was taken by him.
I understand it. See, 30% and 70%.
Yes.
Land is yours.
Yes.
Development will be done by him.
Yes.
And the flats will be sold to general public. Okay. 30% you will get, 70% they will take.
Yes.
Okay. Ultimately whose money? Public money.
Public money was
Those who invested. So you want back your 30% whatever.
32%.
32%. It will be double jeopardy in the situation. See, all the investors has to be paid money.
Yes, 68%. That is the claim has also
Only 68. You have not your share of the flats. You have not sold in the public.
No.
Okay. Then you are entitled.
Yes.
Then you are entitled. Yes. Then you are entitled. Okay. On the request of one letter counsel for the opposite party, leaves the matter also interim or to continue. Good week for a small matter. You come with this proposal. You understood, na? Let us put an end to it. Otherwise, it will go on and on and on. Yes.
My lords have filed an IA for extension of the interim orders, my lords. IA number.
Interim order extension. Extended.
Deeply obliged.
Yes.
64.
64 disposal. Yes. 64. That is FA. You have that?
Yes.
Give it. We'll dispose it of what is the problem. This is item, sir. This is 64. Item 64. And the other one just give. 82 weekly. And appearance. Give both the appearances. Tomorrow this will be. Okay, both the things. Yes. Appearance, sir, have you given the appearance? Both of you. No problem. Yes.
65.
Done. Give. লিখি দেবে তো সেটা রেকর্ড করি আর যা কইবে আর হ্যাঁ ইয়ে
That one is death is due to heart attack as per the inquest report. The I was treated.
Is it relevant? You are paying it finished.
Because on the date of accident took place, I got in course of the implementation for liability compensation. So for the specific ground, I have taken.
I will record your statement, your submission.
Yes.
You write down and give, I'll incorporate that. That's all. Let counsel for the petitioner submit. Let counsel for the appellant. It will be the Kuti, Cooper, hearing who the party serve. Para two putting, para two. Let Mr. Mohali, let counsel for the petitioner submits that the death is death of the disease driver has caused due to cardiopulmonary arrest. Likhi de de. Arrest.
Is a disease, not an accident.
Comma, which is disease, which is natural and not really caused due to the alleged accident.
My effect from the term that Supreme Court will not applicable here because accident took place on 4/8/20, but he died on 17/8/2020. After long, but accident took place in course of the determine only protection that death is due to the accident, not for the other.
However, the accident, however, from record it reveals that the accident has taken place on 4/8/20 and the deceased has died on 17/8/20, which is with a close proximity. Therefore, it is therefore the submission of the petitioner may not be correct in the facts and circumstances.
Yes, small companies, the insurance company not like to pay comment because this is the driver. He had not removed the deal at the time of accident.
Land counsel for the petitioner further submits that the company, insurance company, is not liable to pay the compensation as the driver.
The deceased driver had no deal, not
The deceased driver had no valid driving license, driving license, and since the but the said contention doesn't sustain in view of the in view of the government order dated 17/6/2021, which has happened, which has occurred during the COVID period. Therefore, this contention too is holds no water. Holds no water. Accordingly, the same is rejected. Done. So that your this thing is taken care of. Yes. Yes.
6.
Madam 66, today I am appear on behalf of the Union of India, my lord. Respondent 1.
So and so entered appearance for Union of India.
3 weeks time to file counter, my lord.
And praying for 3 weeks time for filing counter. Let him do so within 3 weeks. Lease the matter. I'll make it 2 weeks then instead of 3 weeks. Okay. And what to do? You change the government so frequently. They change the lawyer. 2 weeks I will give 2 weeks. 2 weeks. Huh? Yes. Okay. 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 Thank you.